Ladies and gentlemen, and welcome to our public hearing into the Commonwealth Electoral Amendment Bill of 2016. I declare open this hearing on electoral matters into the Commonwealth Electoral Amendment Bill. On the 22nd of February 2016, the House referred the provisions of the bill to the committee for inquiry and report by the 2nd of March 2016. The bill proposes to simplify and improve the Senate voting system, improve the ability of voters to express their voting intent, require unique registered officers and deputy registered officers of political parties, and reduce voter confusion by allowing political party logos to be printed on ballot papers. Before the committee starts taking evidence, I remind all present here today that in giving evidence to the committee, witnesses are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to the committee. Such action may be treated by the Parliament as a contempt. It is also a contempt to give false or misleading evidence to the committee. I remind all committee members that the committee operates under the Senate Standing Orders Rules of Debate and Conduct of Senators. Today, as Chair, I will be following a resolution agreed to by the committee to rotate the call for questions so as to maximise participation. I welcome the media who are here today. I ask a member to move that the media be allowed to film the proceedings today in accordance with the rules sent down for committees. Senator Reynolds and seconded by Senator O'Sullivan. Thank you. I welcome officers from the Australian Electoral Commission to today's hearing. Thank you, gentlemen, for your submission to the inquiry. For the benefit of Hansard, would you please state your full names and the capacity in which you appear before the committee?
Tom Rogers, Australian Electoral Commissioner.
Pablo Carpe, First Assistant Commissioner.
Paul Pirani, Chief Legal Officer.
Thank you. I also remind all committee members of Senate Privilege Resolution 116 that an officer of the Department of the Commonwealth shall not be asked to give opinions on matters of policy. I now invite you to make an opening 3-minute statement.
Thank you, Chair, and I thank the committee for the invitation to appear today. I'm aware that numerous media reports and other commentary surrounding the introduction of this bill are mostly centred on the design of the bill, particularly the Senate voting system. I also note that the policy around the shape of our voting system is essentially a political matter and is therefore a matter for this Parliament. I appear before you today to speak to operational considerations and matters of implementation of the legislation. I've said previously and reiterated in the AEC's submission that the AEC is ready to deliver a federal election in line with the legislation in force at the time that the election is called. As I've also frequently said, the more time and resources I have to do this, the happier the AEC will be. At this stage, I have no reason to believe that we could not return the writ within the existing 100-day period set out in the Electoral Act. I've provided indicative advice on costings and resource implications and an estimated 3-month minimum time frame to implement the changes. However, I do wish to emphasise that this estimation and all associated advice is based on the broad shape of the current proposal. Should the bill change significantly, the AEC will need to revise its timing, cost and other resource estimates. I'm happy to provide any advice on any questions that you may have about the operation of the bill.
Well, thank you very much, Mr Rogers. We'll now move into questions and I'll kick off that process. Could I just ask a little more in relation to the timing? So you've indicated that approximately that 3 months is a sufficient time frame for the AEC to adopt any changes that the Parliament might pass. Could you just elaborate a little on that, please?
Certainly, Chair. I have indicated that we would need a minimum 3-month period, and that is absolutely a minimum 3-month period. I want to be very clear. Any change is complex for the AEC, but we are well established to make complex changes. So the 3-month minimum time frame that I've indicated will see us be able to conduct an election and return the writs. There may be some ongoing work after the return of the writs, administrative work, as we continue to adapt to whatever the legislation ends up being. But I also refer back to what I said at the start, that my 3-month estimation is based on the current shape of the bill, and if that changes, I would need to come back and examine that again.
Thank you. I'd also like to touch on the issue of informal voting and the potential impact of the changes in the bill on informal voting. Can I start with below-the-line voting? Could you let us know how many votes were cast below the line at the last election?
Yes, we can, Senator. Yeah, it's approximately 480,000, but around about.
Thank you. And approximately how many of those were informal?
Of the 480,000, it's interesting actually, the low number of informal votes below the line given the number that were cast, but I think it's around about 8,000.
Okay, so about 8,000. So less than 2% of the below-the-line votes were informal.
I'm going to confirm those figures for you.
Okay. As you know, the bill includes a savings provision where below-the-line votes, which effectively can contain up to 3 mistakes now, could in fact contain up to 5 in the future. Have you given any thought to what that would impact that would have had on informal below-the-line voting had that provision been in place at the last election?
Chair, can I say up front that I know there's been a lot of speculation about what might happen if the changes were implemented. I'm very nervous about speculating on voter behaviour. There are a whole range of things that can occur at any election, and for us to speculate on voter behaviour, I know that there are some political scientists who do that, and they're normally fairly accurate, but I really hesitate to speculate on what voters might do because they can do a whole range of things, and so what we think might occur with proposed changes might end up being something very different. So it's difficult for me to give you an accurate picture of what that might look like numerically. However, the current rule that voters are essentially able to make 3 errors and the vote is still considered formal saves a number of votes. Therefore, under the proposed legislation, given that's further relaxed to 4 errors, I would think that it would, 5 I should say, I would think that it would save more votes. That's as far as I could.
And just to be clear, by save more votes, you mean less votes would be informal?
That's correct.
Yes. Okay. Could I also ask you about above-the-line voting? So in terms of the proposed change for above-the-line voting to optional preferential voting, would you agree also that the change is likely to lead to reduced informal voting above the line, given that people can number a number of boxes?
Again, Chair, and I think I'll probably be giving this answer a fair bit today. I can't speculate on voter behaviour. What I would say is from the legislation requires that on the ballot paper, as I understand it, we annotate that voters are required to vote 6 above the line. However, the savings provision that is also provided in the legislation, which is a vote that only contains a vote for 1, would still be formal, would operate, I think, to save a number of those votes. But again, I'd be speculating on voter behaviour, which I'm loath to do. So.
All right. All right. Well, thank you, Mr. Rogers. Now, in accordance with our decision regarding rotating the call, I will now pass the call on to, it would be the Deputy Chair, but in his absence, Senator Conroy.
Could I ask when the AEC was first consulted on the bill?
I just missed the first part.
Sorry, when the AEC was first consulted on the bill?
Senator, during every electoral cycle, a JSCEM hands down recommendations, and we start work fairly early with partner agencies on looking at the possible impact of JSCEM recommendations. This electoral cycle was no different. The JSCEM made a whole range of recommendations. Some of those didn't require legislative change, and we looked at whether we should adopt those straight away. Others we worked with the Department of Finance in a series of working meetings on what the possible implications might be. There were several working meetings with finance and others in 2015 as we worked through possible implications. But Senator, not only is that a usual way that we would do business. No disrespect to the various joint standing committees that have sat over the years. The vast majority of joint standing committee recommendations don't see the light of day in legislation, but we still have to be ready to implement. So we do some work with risk and contingency planning around those issues.
So could I come back to the question I asked you, which was when were you first consulted on the bill before the Parliament?
Senator, my staff provided input into the development of various aspects of that bill, as I've just mentioned, through a working party process with the Department of Finance. I can find the exact dates for you, but we had a range of meetings where we provided input into the overall shape of that process.
But the bill doesn't implement the JCM recommendations, a point you've made consistently. Most recommendations don't see the light of day. So can I come back to the question, when were you first consulted about the actual bill?
See, the problem is ordinarily we'd had the Department of Finance here, that the committee won't allow that.
I'm sorry,
I said the problem is we would ordinarily have the Department of Finance
Senator,
hearing, but the committee won't allow that.
Yes, Senator, I would remind you that you're here to ask questions.
Sorry, you're now gagging.
Remind
You're now gagging
This
the
has made
Senator.
us time, thank you.
And you also don't have the call, Senator. Senator Collins.
I'll happily defer. I happily cede to Senator Collins to make the point, because I was going to make it myself in my very next question. Will you take on notice when you first received a copy of the bill?
My Chief Legal Officer, I think, saw a draft version of the actual bill on the 11th of February. But
Senator.
But before, that's giving a false impression though, Senator. I'm not trying to be cute here, I'm not trying to defend or promote anything, but to give you a picture of the way that we actually develop our policy and electoral cycle. We had input into various components of that before Thursday, the 11th of February, through the working group process with the Department of Finance and through our own risk and contingency planning. But the formal look at a very draft version of the bill occurred, I think, on the 11th, but I might come back and just confirm that for you, Senator.
So you didn't draft the bill yourself, as I think you've indicated. It was drafted by the Department of Finance.
Well, to be accurate, this will sound cute, Senator, as drafted by the Office of Parliamentary Counsel on the advice of the Department of Finance with input from the AECs.
Thank you for that. And so if I wanted to ask you about what the thinking behind an individual clause in the bill was, you'd say you're not in a position to answer that. Only the Department of Finance could answer that.
Well, I'd probably rely on earlier answers, which it's probably not going to help you, Senator, but to say that policy is a matter for government.
Yeah, no, I mean, what was behind the thinking of this policy decision, which then translated into a clause in a bill?
I would say it's a matter for government.
Yeah, or a matter for, if we wanted to ask a question about it. So, Chair, could I just indicate that, as has been evidenced by Mr Rogers, if we would like to ask a question to the people who prepared the bill, it's the Department of Finance, and you've consistently, 3 times when Senator Collins asked for them to be listed, not allowed the Department of Finance to turn up today.
Well, Senator, as you're aware, the committee has resolved as to the who is appearing as witnesses, and that is the basis on which we're proceeding.
What was the basis for refusing? What was the basis for refusing the drafting department to attend the committee?
We have reached the expiration of your time, and I will now rotate the call to Senator Rhiannon.
Thank you, Commissioner. When can you start? Working on the actual implementation of the bill? Is it when the legislation is passed, or on assent, or on the day of commencement? Could you explain that, please?
Certainly, Senator. You won't be surprised to know that we're doing risk and contingency planning right now. It would be, I'd be abrogating my responsibility as the Commissioner if we weren't doing some sort of risk and contingency planning now, but we can't start implementing until the bill becomes legislation. So we're doing as much risk and contingency planning as we can right now, but clearly I can't predict what Parliament may or may not do, so it would be impossible for me to start implementing fully that process right now.
And with regard to the 3 months, could you expand on that, because you've explained that you're already doing some work in terms of because I think that you link the time frame to resources available. Now, does that mean if there was more resources that you could get it done more quickly?
It's also a slightly vexed question as well, Senator, but there are some components where it is easier for us to truncate the time through the application of additional resources. There are many components that go to make up the estimate of the 3 months. Some of those things, yes, if we get more resources, they can be done more quickly. There are some elements, though, that just take time, either because there's a quality process involved, and we have to make sure it's entirely accurate. Some of the work on recoding some of our systems just takes a period of time. There's a point at which even more resources won't assist in shortening that time frame.
And also, could you outline...
Sorry, Senator, and could I also be on record as saying that the 3-month period is already a streamlined 3-month period in any case.
So you're saying it's already tight? And I just want to move on to education, that I'm aware that with each election you do considerable education of the electorate. Could you, is this something you're already working on, and can you outline what your plans are for education, how you would take that forward?
Senator, it's difficult to outline exactly what our plans are with that until I see the final shape of that legislation that comes out of the House. But as you've indicated, out of the process, I should say, not the House. As you've indicated, we are experienced in running national campaigns around electoral issues. We do that at every election in any case. We talk about formality, other information to provide electors with the information that they need to cast a formal vote. So I would suspect that an education campaign that we'll be running at this election, should this bill become legislation, will be along the lines that we've done previously. If I reflect back possibly to the last major campaign we ran, was probably the 2007 campaign with, I think it was The Rules Have Changed, I think was the campaign that we ran. I'm not saying that it will mirror that campaign, but that's probably the last time we did a national campaign of that order. But as you pointed out, at every election, we reach out to electors in any case.
So would there be a requirement to be considering the change that's involved? It's not just educating people to get them to vote, it's now educating them that there's a change.
About the change, absolutely.
So does that mean that additional resources are needed, that it would need to be more extensive, using more platforms? Is that where you're going?
Quite possibly, Senator, and we don't just do that ourselves, by the way. We work with a number of commercial providers and experts in that field to determine what is the best way of having an impact at that point in time. And we use multiple platforms, as you pointed out, particularly with an education campaign.
Okay, thank you. Thank you, Chair.
Thank you, Senator Rhiannon. So we now rotate to a 5-minute block to the crossbench senators who are participating members. I'll start with Senator Day.
Thank you, Mr Chair. Mr Rogers, again regarding educating the electorate, what level of understanding do you think the electorate will have about these changes to voting, the voting system? And what is the likelihood that the overwhelming number of voters will still just put a 1 above the line, which will mean in a great number of cases that their vote will die, or to use the common euphemism, exhaust?
There's a few components to what you've asked there, Senator, and one of those is my opinion about what might happen with voters. And again, as I said at the outset, it's dangerous to speculate on what voters may or may not do.
What's your experience on what voters will respond?
Just if I finish that first bit, it is difficult to speculate on voter behaviour with any change. So with any certainty, who knows what voters may do on a particular day. Our role as the AEC is to provide as much information as we possibly can to voters to ensure that they know how to cast a valid vote during the election period. That's what we do every election in any case. And we have experience in running campaigns to educate voters to changes to the legislation, as I've indicated previously. We did that in 2007. Our public information campaign for 2013 used a whole range of channels. It's just a standard information campaign for a standard election. We used free-to-air and pay TV, radio, press, magazines, online, social media, outdoor advertising, and we also ran campaigns in each state as well. We did a whole range of other things, Senator, to try and tackle the issue of informality. There are, as I've given evidence to this committee previously, a number of seats where informality remains high at most elections, and many of those are, as I've also said to this committee previously, clustered, for example, around Western Sydney. There's a high rate of informality. So we also do things like putting information officers in those electorates where there's a traditionally high level of informality to try and impact on that. So that's, if this bill becomes...
Sorry, how successful was that?
We think the activities that we do at election time actually have quite an impact on informality, but there are a whole range of factors that go to contributing to the area of informality. Senator, we've reported to this committee previously that those areas where English is a second language, where there are a large number of candidates on a ballot paper is the second factor, and the third factor is normally electoral proximity to a state electoral event where a different electoral system may be used. They're, in our assessment, the three big factors that contribute to informality. You've asked me also about the impact of the proposed legislation. If I look at that for a moment, below the line, there is, for the elector, little change to the current system. So I'm not sure that that's going to create a huge degree of confusion for the elector. Again, I'm speculating there, which I said I wouldn't do, I guess. And above the line, given the savings provision that saves a number one vote above the line again, it makes it easier for us to run that campaign to ensure that there's not a huge impact on informality.
So the overwhelming likelihood that 90+% people will still just put a 1 above the line, is that your opinion?
No, it's not, Senator. I didn't say that, I'm sorry, and I can't say that because I can't predict voter behaviours.
Order, Chair. I think we've now gone into the realm of asking the witness to speculate.
We've got experience on behaviour.
Yeah.
Well, thank you, Senator.
No, thank
That's
you
good,
for the
Linda.
thank you for the point of order. I'd remind the senator that the witness is not required to address questions on matters of policy, and I think that it is a speculative question. So, if we could press
he
on.
responded that.
The witness is free to respond if he would like to respond to that question.
And again, Senator, it would be impossible for me to give you an accurate answer about what voters are likely to do.
But you wouldn't be surprised if 95% still voted.
Senator,
I think he's answered the question, Senator. Thank you. So we have we have just under a minute left in your session. Have you completed your questions?
My question, yeah.
All right. Well, we'll come back to Senator Muir and Senator Xenophon in the next round of crossbench questions. All right. So we now rotate back to the coalition question time. What I would like to follow up with you, Mr. Rogers, just in relation to my previous questions on the savings provision below the line and the increase that the bill allows for from 3 errors to 5 errors, so to speak. Has the AEC conducted analysis on what the outcome would have been at the 2013 election had that provision been in place?
Thanks, Chair. We've done very little of what we'd consider to be modelling, but we've done some staff checks for us about what impact that might have on our ability to handle ballot papers. So I have done that specific analysis, but that's pretty much the extent of the modelling that we've done, which is the point I was trying to make previously.
And what did that analysis demonstrate?
Well, at the 2013 election, there were about 68,000, in fact 67,816 ballots below the line that were saved because of the current savings provision. So there were 67,000 ballots that were saved because of the current 3 errors saving provision. Under the proposed system of 5 errors, that number of saved ballot papers would have increased to 71,873. So that's an additional 4,000 and odd ballot papers that would have been
Yes.
saved had the...
And that would be reduced from the total of informal votes, is that correct?
That's correct.
I-
But even when I say that, Senator, Chair, that's slightly difficult because some of those additional ballot papers that I've just mentioned, the 4,000 odd that would have been saved, may have been formal above the line in any case. But so it's a bit hard to disaggregate, but that's my best guess. It's around about 4,000 that would have been saved.
And I think we'd previously said that it was about 8,400, I think you'd mentioned, as the informal below the line.
That's correct.
And so the provision would have effectively reduced it, as you say, by about 4,000, so about half, so to speak.
Yes, Senator, and again, we'll confirm those exact figures
Sure.
for you.
And I think you'd said before, you mentioned the total number of below-the-line votes. So if you had this provision in place, it would suggest that the informal vote below the line would, in fact, have been less than 1%.
Chair, I'll have to confirm those numbers for you, but
Okay.
again, without speculating on voter behaviour, which I cannot do,
Yes.
if these had been in place in 2013, by default, the savings provisions are more relaxed, if you like, more advantageous for the elector. By default, it would save more votes.
So by definition, if it saves more votes, the informal vote must be lower.
That's correct.
Thank you. I'll pass to Senator Reynolds to ask a
Thank you very much, Chair, and good morning, Mr Rogers. I just want to go through for the benefit of the committee and just make sure that I've understood and we've understood your testimony so far. So the first thing is that you said that since the committee issued its report in May of 2014 on Senate voting practices, your testimony is that the AEC has been reviewing, in terms of risk and contingency, you said, what would happen and how you would implement the recommendations. So is that correct? You've been looking at it for nearly 2 years?
That's correct, Senator, and it's not unusual for us to do that. And again, as I mentioned before, I'm not trying to be offensive to the Joint Standing Committee, but every electoral cycle, the Joint Standing Committee produces a whole range of recommendations. Many of those require legislative change, and many of them never see the light of day as legislation.
But you've still done the contingency planning,
because we have to be ready.
If and when the Parliament wants to implement them, you're ready to do it.
That's correct, Senator.
So in this case, you've been looking at it for 2 years and doing the contingency plans on the JSCAM recommendations. And you've also said, I understand, that you've been working in more recent times with finance on the detail of those recommendations and looking at drafting. So you were involved in the drafting of this current bill with finance.
Senator, we've done a whole range of risk and contingency planning, which we do every electoral cycle. One of those things, given what occurred in 2013 and the discussion in the JSCAM paper about Senate voting, we spent some time unpicking our internal processes with the Senate voting in any case, because I wanted to be sure that we knew exactly what we could change, how we could change it, the impact of those changes, risk and contingency.
So in all that planning, Mr Rogers, presumably your legal counsel has been involved in the process, had a look at the draft that OPC has done. So has either OPC or your own legal counsel identified any constitutional barriers to the proposal that you've been looking at for 2 years?
And let me be precise here,
Please.
Senator. We haven't provided constitutional advice, and it would be inappropriate for me to be providing constitutional advice.
That wasn't my question. My question was, has anybody raised with the drafting any constitutional issues?
My chief legal officer has seen, as I said, saw a draft version of the bill. My presumption is that in the drafting of the bill, constitutional advice was sought, and the bill would be drafted in a way that made sure that it took account of that constitutional advice.
We need to move on. Thank you, Senator Reynolds. We now turn to the Labor questions. Senator Conroy.
I just want to follow up on a point that Senator Day raised. In terms of voter education programs, and I think this is really what Senator Day was trying to get to. In the past, when there's been significant changes, and I'm showing my age now, there's been significant voter education campaigns, TV, advertising, that sort of thing. Are you seeking any extra funds from the government to engage in a voter education campaign? And if so, how much?
Senator, you're right. Normally there's a voter education campaign, and I think I indicated in my answer to Senator Day that the last time we did a major change education campaign was, I think, in 2007, which was about the introduction of close of rolls. We ran a campaign using multi-channels, which you would expect that we would do to get the message through to the voter. If this legislation becomes law, we will run another education campaign about the changes to ensure that voters are aware of what the changes are. But, Senator, we'll probably tie that in with our standard campaign in any case. At every election we run a whole series, as you know, of advertisements telling electors about what they need to know to be able to cast a formal vote. But there will be additional costs for that, and we will be seeking additional funding.
Have you put in a supplementary budget?
We're working with finance at the moment on exactly how much that will cost.
No, have you put in, I mean, there's a formal process where you submit documents, I've been through it.
We are working with finance at the moment, Senator, on those costs, and the reason I'm being slightly non-specific also is there is a commercial element to that, and part of that is commercial in confidence because we use external providers. So we're working with finance on what the cost would be, but I'm also trying
You're not going to tell us how much you want to spend on an advertising campaign. Is that commercial in confidence?
I would prefer, Senator, at this stage to not say that because there's a commercial in confidence element to that particular part of the campaign. What I am telling you, there'll be extra money required. I've made that very clear through the process at the Joint Standing Committee, Senate estimates, and in our work with the Department of Finance. But what we're trying to do at the moment is to look at how much of that campaign we can piggyback on the back of our standard work at election time in any case. So.
Now, you don't get allocated budget funding to run an election each financial year, do you?
No, we are funded separately to run an election, Senator.
So do you have funding to run an election in this financial year?
Senator, I know this sounds as if I'm being evasive here, but the way that our funding is actually scheduled and structured enables us to call forward funding to do preparatory work in the year before the election. So it's not a clean cut, come the financial year of the election, we start spending money. For example, Senator, for us to stock on a simple matter like cardboard, we generally stock in the year before an election. So we spend essentially what our election funds in the year before the election is called. So we are always spending money on an election, and we have an agreement with finance for how we receive that money and able to spend it.
Have you requested the funding to run an election in this financial year?
Senator, we've requested no extra funding beyond which we would normally request to run an election. I need to specify that I've said previously that the next election, whenever it occurs, is likely to be more expensive than any previous election we've ever run because of the changes we've made as a result of the Kilty and ANAO recommendations based on the 2013 election. So.
Yeah. Now, regarding the recent amendments to resolve issues identified in the bill, did the AEC identify the flaws in the bill introduced to the House, or did someone else identify the flaws?
You'd have to specify what flaws you're talking about.
Well, there's been an amendment moved in the House of Representatives. Let's just start with that one.
This is the counting on the night.
The first reading and the third reading.
That was not from the AEC.
Okay. Do you know who it was from?
No, I don't.
Chair, it would be helpful if we could ask somebody who...
Well, Senator, you can ask questions
Well,
of
they've said it's
the
not
witness.
them.
Well, the witness
I
has
assume
answered...
it's the Department of Finance?
The witness has answered your question, Senator.
Is there any way we can ask the Department of Finance why they drafted an amendment to the government's own bill?
Senator, questions related to the Department of Finance are not a matter for the AEC. The AEC Commissioner has answered your question.
But questions to the Department of Finance would be a matter for the Department of Finance?
Questions related to the policy matters related to the government can be addressed to the relevant minister. The witnesses in this...
Can we call the Minister? Is the Minister available?
Senator, as you're well aware, there are mechanisms for you to ask questions of the Minister in the Senate. This is a public hearing and our witness is the AEC who has addressed your question.
It would just be helpful if the Department of Finance who drafted the bill were here for us to ask why they put forward an amendment to the original bill.
You've obviously sought to make that point, Senator. You've got about half a minute remaining on your time.
Now, can the AEC provide copies of all written communications with the government in relation to the bill?
All written communication with the government regarding this bill. we certainly take that on notice, and we'll take that on notice, Senator.
How quickly can you get it to us? As you're aware, we have to report by 8 o'clock tomorrow morning. What are our chances of you being able to give us that information?
We'll look at that today, Senator.
All right. Thank you, Senator. Thank you, Senator Conroy. Now I pass on the call to Senator Rhiannon.
Thank you, Chair. As you know, there's a requirement in the bill that people should number a minimum of 1 to 6 boxes. Should there be a penalty for anyone advocating just vote 1 above the line?
That's absolutely not a matter for me, Senator. That's a matter for government, but...
We need the department.
We need the department to help you there, Senator Rhiannon, but you voted not to have them.
So, so just in terms of understanding how that would work, in terms of the result, when people go to vote, that's not something you give advice on?
On the ballot paper, under the proposed changes, there will be an instruction for people to complete 6 boxes above the line, Senator, and that will be very clear on the ballot paper. That will be advice that we are providing people through our education campaign, that they should vote number 6 boxes above the line to cast a formal vote. As you're aware from the legislation, however, if people don't do that, there will be a savings provision that still renders a vote of number 1 above the line formal.
So when there was the Albert Langer case back in the 1990s, was advice given at that time about, because the law was changed with regard to what was, I understand the law was changed with regard to the instructions. So,
Senator, the Langer case is different from the current proposal, and I might ask my Chief Legal Officer to talk about that.
Senator, the Langer case principally dealt with the issue about whether there need to be consecutive sequence of numbers on a House of Representative ballot paper. Since that time, the Act was amended to make it clear that it was a consecutive sequence of numbers that's required for a formal vote. There was at that time also Section 329 capital A, which had a criminal offence. The JSCM at that time recommended, on the AEC's advice, that that provision should be repealed because it was too difficult to administer.
So the AEC gave that advice at that time.
And the JSCM also included it in its report,
Yes,
which led to the amendments which changed the legislation for voting in the House of Representatives. Yes.
So would that be advice that we should be mindful, the advice that the AEC gave to JSCM, that JSCM adopted at that time, should that be advice that we should be mindful of with regard to the instructions and also the enforcing any rules with regard to the required numbers above the line?
Senator, I think we're talking about 2 different issues here.
I know it's 2 different issues. I totally appreciate it's 2 different issues.
The issue at the moment is whether, if a person was to say vote 1 for a Senate candidate, would that be misleading an elector as to how they would be marking their ballot paper so as to lead to an informal vote being cast? Now, the High Court has dealt with those sorts of comments in Evans and Crichton-Brown, and the Federal Court more recently dealt with it in the case of the Reverend Peebles and the Honourable Tony Burke about the scope of Section 329 of the Electoral Act, which is the relevant provision that applies where there is misleading and deceptive advertising about how an elector should mark their ballot paper. Again, I stress that the bill says that the electors should be marking at least 6 squares above the line in the current bill.
But it's precisely on that point. I appreciate that the 2 issues appear very different. However, there is a similarity surely in terms of misleading how one marks up the ballot paper, because wasn't that the case with Mr Langer, that he ended up, I think he spent 10 days in jail, and I understand that that was one of the reasons, or maybe the key reason, that advice was given that really the law wasn't working in that form. So my question is simply, isn't this something we need to be mindful of in deciding on these details?
Senator, Mr Proney can correct me if I'm legally incorrect here, but the Langer case is different from what's being proposed, and I know you've acknowledged that. The ballot paper will contain very clear instructions to voters to vote 6 above the line to enable them to cast a valid vote. What we can't do is mandate what all the parties may or may not say, but our advice to voters, our education campaign to voters will be to complete 6 boxes above the line. There'll be notification in the polling place along those lines as well. However, if theoretically, hypothetically, if someone did advise voters to vote 1 above the line, they'd still be advising voters to vote formally.
All right, well, thank you, Senator Rhiannon. Can I just, we'll come to you in a moment, Senator. Can I just make a point of clarification? I think during that exchange a couple of times it was mentioned that the ballot papers will say to mark 6 above the line, whereas the legislation provides for at least 6.
At least 6 above the line.
I think you, Mr Pirani, did make clear, but I just wanted to clarify that point. All right, so we now move on to the crossbench questions. We have a 5-minute allocation. I'd propose that Senator Muir and Senator Xenophon both seek to ask their questions during this time. Senator Muir, I would give the call to you.
Yep, this is the most biased and unbalanced committee I've ever been in, but anyway. In your submission, you mentioned 3 important things: time, funding and resources. We don't know when you will have, we don't know if you'll have enough time to prepare for these changes because we don't know when the election is, apparently. Can you tell the committee if you've been advised by the government that they will provide the AEC with sufficient funding and resources in order to carry out the necessary system and development implementation?
I think when the Minister made the public announcement about the introduction of the legislation, he mentioned that elections are essentially a demand-driven process, and that we would be provided the resources that we need to complete the task. You're absolutely correct, Senator. If I can endorse what you've said in terms of time, funding and other resources, they are critical for us. It's also why when I started today I made the point very clearly that all of my estimations are based on the current shape of the legislation. And if the legislation, if the bill that will be put before the Senate changes significantly, I will need to review that to see what impact it might have on our estimations of timing and resources. But if we don't get the time we need, if we don't get the funding we need, it's going to be very difficult for us to implement.
All right, so there's been no time advertised at this stage. The Joint Select Committee into Electoral Matters has made recommendations on that. Does the AEC see that that's involve recommendations of or the view of the 1 in 4 voters that are voting in other areas rather than just the major parties?
Again, Senator, that's a matter for Parliament, not a matter for the AEC.
How much time does the crossbench have left now?
We have 3 minutes, so if you'd like to ask one more question, we'll pass on to Senator Xenophon.
Considering this education process is apparently going to be very effective, why do we need the savings provision in the first place?
Again, Senator, you're asking a question that is not a matter for me, it's a matter for this Parliament.
Right. It's a matter of policy. Thank you, Senator.
So for the department, that should be here.
Thank you, Senator. All right, we'll rotate the call to Senator Xenophon.
Some submissions are quite critical of the proposal to require little change to below-the-line voting, rather than, say, a minimum of 12 boxes being filled below the line. If the bill were amended to require a minimum of 12 boxes below the line, what practical, technical hurdles would there be in addition to what is being currently proposed in the bill?
I suspect my answer is not going to be helpful here, Senator, but that's a matter that I haven't considered. I'm looking at the implementation of the legislation that's currently before the House. There are probably a whole range of practical and technical reasons that may or may not be associated with that, but I haven't looked at that, Senator.
Excuse me, Senator. The call is with Senator Xenophon.
Thank you. But it would require us to do more work now to work out how that would occur, yes.
Yeah. Can you, my final question is, can you in the limited time available get back to us to consider, reflect on that by this afternoon, please?
I'll do my best, Senator, to find out, to ask some questions internally about it.
Thank you, Senator Xenophon. We'll still have a minute or so for Senator Lyneham would like to ask a question.
Thank you, Chair. Mr Rogers, have you addressed the issue of how you would place logos on the ballot paper? What prominence do you anticipate that they would have? And I know that legislation says that a maximum of 2 will be permitted. How do you propose to accommodate 2 logos on the ballot paper?
Yeah, we have started looking at that, Senator. My answer is going to be dependent on how many parties and groups actually register for the election, because that will determine the space of the ballot paper. But we've started doing work on laying out the logos. We've done a very rough look at what that might look like. Again, the size of those logos, how they're portrayed on the paper, will be largely dependent on the number of candidates that also appear on that paper. As I've said to the committee previously, the size of the Senate ballot paper is largely fixed at the moment, as I understand it. The numbers that we need in the time frame that we need, the maximum width I think is about 1 metre, and it's around about 1 metre in any case. So we're working within that space. It's why in the 2013 election in New South Wales, the font size went down to 7.6 font, I think, and we needed to, at short notice, procure magnifying sheets. If far less people nominate for the next election, it will be easier to render the logos. If the ballot space is as crowded as it is at the moment, it's going to be slightly more complex.
And I assume they'll be in black and white?
That is correct, Senator. That's my understanding.
Thank you, Mr. Rogers. All right, we'll move on to the coalition allocation, and I'll give the call to Mr. Passon.
I just want to go for some clarification, if I can, through you, Commissioner, perhaps to Mr. Pirani. With reference to the bill and having seen it and considered it, is it the state of the AEC's evidence that they have no concern with respect to its constitutionality?
I might answer that first, if you don't mind, Mr. Passon. We've made no comment about its constitutionality. I've made some comments about our involvement in the process. My presumption that constitutional advice was sought, as it is for all legislation in any case. I'm also aware, Mr. Passon, there's a large amount of speculation about that particular issue, and it's been canvassed in some of the submissions, and I haven't read all the submissions. And some of that turns on the constitutionality of the below-the-line part of the ballot paper. We don't have a constitutional position on that, but I guess if I look at it, to the extent that the current system is constitutional, I would make a presumption about the constitutionality of what's been proposed, given it's essentially the same. But that's not legal advice. I'm not a lawyer, and that's where we are at the moment. So,
Commissioner, the AEC has been doing a Herculean amount of work as a result of the well-publicised failures following the 2013 election. Of course, you've been reporting to JSEM in another capacity regularly. Are you confident that in addition to that work, which as I say has been Herculean, that you'll be able to implement these changes satisfactorily and comfortably in line and in time for the forthcoming federal election?
Mr. Passon, as you indicate, we've been doing a substantial amount of work and largely reforming all of our operational processes for the next election. We've trialled many of those systems in the Griffith by-election, Canning and North Sydney by-elections, and in the rerun of the WA Senate election. But that's a work in progress for us, and will be a work in progress for some years. There are some elements of the JSCAM report and the ANAO report that speak to the AEC's culture. Culture is not changed in the space of a week, it's changed over a long period of time, and so we're still in the middle of many of those changes. You asked me, am I confident? Yes, I'm as confident as I could possibly be, Mr. Passon, with those changes. I've said to this committee previously, though, I don't think there would be a commissioner that would sit here and tell you that any election is risk-free, because we're using people and processes, and that's an issue. I've also said to this committee that there are two sorts of risk, I guess, with the current proposal. One is we don't get the time and resources that we need to implement, and the second is what I've deemed as cumulative risk, which is the risk of all the changes that we've made on top of new changes. However, I have provided a 3-month indication of time, and I stand by that 3-month indication of time. I've made it very clear that the AEC stands ready to deliver an election whenever the government calls it, with the legislation that's in force at that time. If I get less time and resources, internally that's not going to be a pretty look, Mr. Passon, but we will deliver a successful election. So to that extent, I'm confident.
Thank you, Mr. Passon. Just to pick up on your comment before regarding constitutionality, Mr. Rogers. You made a comment to the effect that, to the extent an argument is made that the proposal is unconstitutional, that would imply that the current system itself was unconstitutional as well. Could you perhaps just elaborate on that?
I'm nervous about elaborating on that, Mr. Coleman, because I'm not a lawyer and certainly not a constitutional lawyer, and I've said previously we haven't provided constitutional advice. However, I've read some of the submissions. I've noticed some others popped up late, and I haven't read through those, but I noticed particularly the submission by Professor Williams, who I think might be appearing here later this morning in any case, who essentially made that point that you've just said, as have a number of commentators. So.
All right. Thank you, Mr. Rogers. All right, we now rotate the call to Labor Party Senator Conroy.
I think this will be my fifth or sixth question I'll be allowed, so I'll be as quick as I can. Now, Mr. Maley has put in a submission. Are you familiar with Mr. Maley?
I am. Mr. Maley's a former employee of the AEC.
Yes. Some have said to me that he was the AEC's Senate voting expert. Is that an unfair characterisation, or is that a little over the top, that he was your leading person in this area?
Senator, he's a terribly decent chap.
A terribly decent chap. Does he have expertise in this area?
He absolutely does.
Have you read his submission?
I have.
Do you have any comments around his view that a vote above and below the line cast in the same way one would be formal and one would be informal?
He's expressed a number of different views in his articles, including about more operational aspects of our implementation of those proposed changes. But I have no view on what is essentially his political statement around the dichotomy between the above the line and below the line. I understand what he's saying, but I have no view on that, Senator.
Okay, so just to clarify a discussion we were having a little earlier, it is valid to vote just number one in above the line.
If you vote just one above the line, you'll be casting a formal vote.
And just 1, 2, 3, formal vote?
Formal vote.
And 1, 2, 3, 4, 5, 6, 7. Is 7 counted? Is it a formal vote if there's a 7?
It's a formal vote, Senator, yes.
And you keep going 7, 8. So you could actually vote 1 to 140 above the line if there were 140 boxes?
You could mark 1 to 140 if there is the unfortunate position where there are 140 boxes.
It'll be a very long ballot paper.
No.
So just to clarify the answer to Senator McDonald's question?
Yes.
They'd all count, they'd all be formal.
That's right.
Now, in his submission to this inquiry, Peter Brent suggests that without a specific prohibition on encouraging just vote one, a lot of people will do exactly that. Do you share that assessment?
Again, Senator, in not trying to be unhelpful, but that would be speculating on what people do. I can tell you what we will do, which is to advise people to cast a formal vote.
Thank you. Given you must have studied the way the state elections, which has optional preferential voting, happens, and voter behaviour, you are in a position to have studied all of these areas. I'm a little surprised you're not able to give us, much like Senator Day asked, an opinion on the amount of people that will just vote one. If you're sitting here publicly telling them it's a legal vote, and if there is no...
Senator, what I'm sitting here telling you is what the AEC will do, which is the bit that I can control, which is we will be advising voters to cast a formal vote in accordance with the legislation by voting a minimum of 1 to 6 above the line. What we find at every election is that voter behaviour changes in any case, and there are so many differences between the state and federal systems, it's difficult to make an analogy between those two. So I'm not trying to be unhelpful, I'm trying not to mislead the committee by letting them know or speculating in an area that may be completely inaccurate.
So you haven't modelled or done any assessment of how many million people will just vote one?
No, Senator.
Yeah, please.
Can I
jump
just
in?
ask,
Senator Collins.
you've taken on notice Senator Conroy's earlier questions about the working group. Could I ask you to be quite fulsome in terms of who participated in it, how many meetings occurred? You've said essentially no modelling occurred as part of that process. But we would like to know which element of the Department of Finance, which Minister's Office has had carriage of this, what consideration you're aware has occurred within government, because at this stage it seems we're not going to get the chance to talk to government. So we'll ask from your end, please.
All right. You have another half a minute if Senator Conroy, another question.
Oh, I don't want to waste it. Now, what role, thank you, Senator Rhiannon, what role did the AEC play in the design of the ballot paper that appears in the bill to be contained in Schedule 1 of the Act?
Senator, I was and one of my staff were present with OPC and people from the Department of Finance when there were discussions about the wording of the instruction and the shape of the Senate ballot paper.
So you had a role in the design of the ballot paper?
We were there when it was being discussed, yes.
Well, my time is up, so I have many, many more questions. I'll put them on notice and hopefully you'll be able to complete them before midnight tonight.
Thank you, Senator Conroy. So we have about 3 or 4 minutes remaining for these witnesses. I'll pass on the call to Senator Rhiannon.
I'm happy to pass to the crossbenchers, Chair.
All right. I might commence. Senator Leinhelm has probably had the most limited opportunity so far. So, Senator Leinhelm, if you would like to address some further questions.
Thank you, Mr. Rogers. In New South Wales, for the Legislative Council, voting is optional preferential above the line. So vote 1 is valid. You can go further if you wish to. The experience is that 90% of voters just vote 1 above the line. Do you think that's indicative of what's likely to occur in Senate voting under the proposal?
I think, Senator, this is a similar question to one
Again,
which was
Senator,
asked before, which is an opinion.
That's a relevant question.
Again, Senator,
address the question.
Speculating on voter behaviour, and I know it sounds as if I'm being unhelpful. I'm deliberately not trying to be unhelpful, but it is absolutely speculating on something that we won't know until after this occurs.
You might think, though, that if voters do that under state elections with very similar rules, that they might do the same thing in the Senate.
Again, Senator, that I'd be speculating.
Speculating, all right. Do you have any views? Now, no, I'm going to change my question. You referred in earlier evidence, I was watching you on closed circuit TV, that you required 3 months to implement the legislation. Is that 3 months between when the legislation is passed, or are you sufficiently comfortable that the legislation is foreseeable so that the 3 months clock starts now?
The 3-month clock does not start now, Senator. As I mentioned earlier on, we are doing risk and contingency planning, and we're doing as much as we possibly can. But until the legislation passes, it's difficult for us to actually implement, which is a point I made earlier on. So the 3-month period from me is from when the legislation passes.
All right.
But we are working as much as we can at the moment to prepare for the possible legislation.
Thank you. One final question on this. We're going to see what effectively amounts to optional preferential voting for the Senate, but compulsory preferential voting for the House. What contingencies would be required, or what preparations would be required to allow for optional preferential voting for the House as well?
That's not a question I can answer today, Senator. We haven't looked at that.
Haven't looked at it, all right.
All right, well, we're coming up to 9:15, which is the time for the next witnesses. So Mr Rogers, Mr Carpe, Mr Pirani, thank you very much for appearing before us this morning.
Thank you. Thanks, members.
Well, people have been asking questions during the hearing.
Report in by 8 a.m. tomorrow, so it's beside the point.
It's a matter for the witnesses, and they'll return in due course, and the answers will be published on the Commission website. Sure. Yeah, the answers will be provided to the committee, and then the answers will be published on the committee website. It's when the witnesses return the answers. It's a matter for the witnesses.
Yeah, that's where it printed everything.
Good man. Put him in witness protection.
All right, well, we'll move on.
Mr Chairman, point of order. Point of order.
Yes.
My question goes to the issue of questions on notice. When will there be, what is your ruling in regard to the return for questions on notice? When will they be available to the committee?
Questions on notice will be provided by the witnesses in due course and
No,
will
but
be
the report's
published
due
on the
tonight.
committee website.
Will they be ready before the committee writes its report?
Senator, as you know, the committee is required to report back to the Parliament by tomorrow, which it shall do, and it is a matter for the witnesses as to when they are able to respond to questions on notice.
Well, the normal practice
is
as a committee is to determine a point at which questions must be returned. Have you done that?
Senator, I provided you with my ruling on this matter. This is a public hearing and we have a witness
Yes, that's
to
right.
be
And there's a
hear
point
from.
of order being raised.
And
a public hearing.
We shall move on. All right. So we'll move on to the next section in the agenda, and we welcome our witnesses, Professor George Williams, Mr. Anthony Green, Dr. Malcolm McKerris, and I believe via teleconference we have Dr. Kevin Bonham.
Yes, I'm here.
Thank you, Dr. Bonham. I thank each of you for your submissions to the inquiry. Now, for the benefit of Hansard, would you please state your full name and the capacity in which you appear before the committee? Starting with you, please, Senator Williams.
Yes, it's Professor George Williams, appearing in a private capacity.
Thank you.
Anthony Green, appearing in a private capacity.
Thank you.
Malcolm McKerris, appearing in a private capacity, but I am a visiting fellow at the Australian Catholic University.
Thank you, Mr. McKerris. And Mr. Bonham?
Dr. Kevin Bonham, appearing in a private capacity.
Thank you, Dr. Bonham. Now, you've each been asked to.
How we're going to proceed? Are we inviting them each to make a 5-minute opening statement?
I'm just getting to that, Senator Conroy. Each witness has been asked to make a 3-minute opening statement in accordance with usual practice. They will go through that now, and then we will go into questions as we had with the previous witness. Now starting with you, Mr. Williams, Professor Williams, if you could still please provide your opening statement.
Thank you, Chair, and I certainly won't begin by rehearsing at length the arguments as to why the current system has some serious problems. They were well dealt with in this committee's report. I'll simply say, of course, that this bill must be judged against the fact that it's been identified that the current system does not do the job appropriately of translating voters' preferences into outcomes, and that there is a very real possibility that due to voters losing control of their preferences, they may end up casting a vote even for a candidate or party opposed to their true preferences. So I welcome the bill on the basis that a fix is clearly needed for this problem. What I would like to do is saying that even though I strongly support in principle the bill and believe it should be passed, that there are 2 amendments that I put to the committee that I believe should be considered. The first of these I believe is important, though not essential. The second of these I think is essential before the bill is enacted. The first amendment relates to the savings clauses, which has already been ventilated, do not also come with a provision which prescribes a person advocating a 1 vote in the Senate ballot paper for a party. My view is that further protective measures need to be introduced into the bill to ensure that people are unable to produce how-to-vote cards and other material that could effectively turn this into a de facto vote 1 system. We have had provisions of this kind in the past dealing with House of Representatives voting. They are upheld in the Langer case by the High Court. Court. It was a different type of provision, but the principle there does stand for the fact that it is possible for this Parliament to legislate in a way that removes the possibility of confusion, where there's a difference between how to vote cards and advocacy and the instructions on the ballot paper, and also the possibility for exploitation, whereby candidates and parties can advocate a vote that is saved but is clearly not the type of vote that is contemplated by the system. I believe that type of measure is important here. The second amendment that I'd press upon the committee relates to the fact that, in my view, the legislation, while welcome, only does half the job that is required to fix the system. I note that the committee is dealing with its own recommendation for fixing the system. It delivered a well-integrated recommendation which argued for both reforms to above-the-line and below-the-line voting. It's notable that those reforms went together as one recommendation. Indeed, they need to be considered as one recommendation because the fixes themselves are interrelated in terms of bringing about a new system. Unfortunately, the bill only does half the job because it only deals with above-the-line voting. As a result, we'd have a system which is unduly onerous when it comes to below-the-line voting, a system that's actually incoherent, in the words of one witness, a statement I agree with, because you end up with an optional preferential on the one hand and a full preferential system on the other for below-the-line voting. What we'd also have is a system that, when it comes to below-the-line voting, runs completely counter to the driving imperative behind this bill. That is, ensuring that voters' preferences are fully respected in terms of the counting of votes. We would have that for above-the-line voting, but we would retain a below-the-line system which still embraces exactly the problem that this bill ought to be fixing. That is, that voters would have no practical way of actually voting for candidates within party blocks except by adopting an onerous and difficult method that we know very few Australians are likely or be willing to adopt. Another problem with the below-the-line method being left as is relates to the possibility of a High Court challenge. In my submission, I take the view that a challenge is unlikely to succeed. I would, however, say that a challenge would be improved by the current state of the bill. That is, the discrimination between above and below-the-line voting is no doubt an argument that would be put in any High Court challenge in suggesting it's an incoherent system that does not properly reflect the need to directly choose the representatives. I don't overstate that by saying it's likely to succeed, merely wisdom would suggest fixing that problem, lest it does go to the High Court. The last comment I'd make about this problem for the Second Amendment is that if there is a justification for expedition on the part of this bill, it is surely that this committee is simply implementing the very lengthy process and recommendations that it reached at an earlier time. My own view is expedition may be justified on that basis, but I can't see it's justified if indeed we simply have some cherry-picking of the committee's findings to produce a bill that actually not only is not fairly representative of that recommendation, but actually causes some further harm as a result. My view is that the recommendation should simply follow the committee's finding, that is optional preferential for at least 6 below the line. I know it's been suggested 12 as an alternative. I favour 6 on the basis it brings parity between the two systems, but I would say also that the driving need perhaps is simply to follow this committee's decision at that earlier time. Thank you.
Thank you, Professor Williams. Mr. Green, thank you.
Look, it's a pleasure to again appear before this committee. I first wrote on this issue of preference harvesting, giant ballot papers, unreadable fonts on ballot papers, and the difficulties voters had dealing with this back in 1997, 2 years before it first emerged at that year's state election in New South Wales, where there were 81 columns, 264 candidates in a ballot paper 1 metre by 700 millimetres. Since that election, New South Wales has resolved the problem that was occurring there, has introduced a system which was basically recommended by JSCEM, and I've done considerable research on the ballot papers that have been used at those by-elections and would happily at those elections, and will happily answer any questions on those subjects. I've appeared before this committee at every election since 2001 warning that this would occur. At federal level as well, and I've sort of made 1 or 2 famous appearances before the last federal election warning we're about to get giant ballot papers that couldn't read. And it's always nice in my profession to actually get a prediction right, so it's one thing I can be proud of. The proposed system that was put forward by JSCEM does resolve most of those issues. I think it has a number of very good features. It puts the expressions of preferences back into the hands of voters. It doesn't. It was if the below-the-line option had been better than is proposed in this bill, there would have been less herding of voters into using the above-the-line option. I think it's regrettable that an easier option of voting below the line has not been included in this bill. As George says, it does open the way for someone to use that as a foot in the door for a High Court challenge, even though it may not undermine the bill in the end. The system is therefore weighted in favour of candidates that campaign for votes, and it's weighted against candidates who do no more than campaign for preferences. I do think that I'm pleased the bill has kept the savings provision so that if someone just votes one, as they've done for the last 30 years, their vote will not become informal. It was very important that any change we made did not declare votes that were currently formal as informal. So I think that's very good. I'm very pleased that savings provision is there. Apart from that, I think it's good that we're moving on this. It would have been good if it had moved earlier in this term. The report was 2 years ago. It's regrettable it's now occurring now. And apart from that, I'm happy to take any questions on how the New South Wales system has worked and my views on how I think this will work.
Thank you very much, Mr. Green. Mr. McKerris.
Section 7 of the Australian Constitution commands that, quote, the Senate shall be composed of senators for each state, directly chosen by the people of the state, voting as one electorate, unquote. Section 24 deals with the House of Representatives. Members there are also commanded to be, quote, directly chosen by the people, unquote. These provisions mean that the electoral system for all our federal politicians must be candidate-based. The Commonwealth Electoral Amendment Bill, as it now stands, is breathtaking in its contempt for the Australian Constitution. It is a bad bill. It should be withdrawn and redrafted to bring it fully back to comply with the Constitution. All three contrivances introduced in 1984 must be scrapped. Any suggestion that the contrivances should be cherry-picked merely to suit the convenience of three big political parties, one big independent senator or the Australian Electoral Commission must be resisted. If any of the above is not implemented, it would be the duty of a senator to take the matter to the High Court the day after the Governor-General signs assent. I am confident such will happen. If that challenge fails, I would be devastated. I would no longer be able to say that our senators are directly elected by the people. Who would I blame? In the first place, I would blame the arrogance of Dr. Evatt and the Labor Party in 1948. In the second place, I would blame the bloody-mindedness of the Liberal Party in 1974, 1975 and 1983. In the third place, I would blame the filthy 2016 deal between the Liberal Party, brackets, led by the unelected dud Prime Minister Malcolm Turnbull, and the Greens, that party noted for its moral vanity. For the past 2 years, I have been urging the Labor Party to withdraw from the effective big party conspiracy represented by the Joint Standing Committee report of May 2014. I am pleased they have now done that. So, 2 cheers for Bill Shorten and his caucus. I wish I could have said 3 cheers for Labor, but I cannot. To my friend Gary Gray, I thank him for giving me his How to Vote Labor in brand slip, which I attended to the committee today. I regret his decision to spit the dummy in his speech last Wednesday. I tendered to the committee a Tasmanian state ballot paper which shows what a half-Senate election ballot paper would look like in principle under a decent reform. Such a Senate ballot paper would say on the top, number the boxes from 1 to, here insert the number of candidates in order of your choice. On the bottom of the ballot paper would say, your vote will not count unless you number at least 6 boxes. I illustrate a How to Vote Labor slip by showing on one side, coloured, the actual flyers handed out in the division of Brant. On the other side, I show what it might have looked like under a decent reform. If asked, I shall explain to the committee how I constructed the black and white side of the flyer. In the program today, I am shown as not having made a submission. However, I've chosen an alternative. Last Thursday, I sent to the committee a 23-page document describing my writings since the 2013 election. On page 18, I quote from an article by Crispin Hull, a respected commentator of the Canberra Times. That article is so important to my case, I have decided to give you a full copy of the article. I look forward to the inevitable High Court case with both fear and delight. My fear is that the court will use the precedent of Mackenzie to give the okay to a rotten piece of legislation. My delight is at the prospect of the court striking down the enactment and telling the grubby politicians how to enact a decent reform. Think of that. The politicians really would be able to sell the reform as legitimate in that circumstance. Quote, we did this because the High Court told us to, unquote, would replace the current spin of, quote, a parliamentary committee unanimously told us to do this, ... and we waited 2 years before we decided to rush it through, end of quote.
Thank you, Mr. McHarris. I would note that your submission has been published as of last night. Now we turn to Dr. Kevin Bonham to make a statement.
Okay, I hope you can hear me okay on the mobile phone. I hope the sound comes through all right. I've sent in a submission where, among other things, I include some simulations of outcomes under this system if the same votes were cast using this system. And I will say that generally the proposed system will produce quite similar outcomes to the proposed J-scheme model, which we've all been talking about for quite some time. Probably the major differences are that it provides more opportunity for parties to catch up on preferences, particularly to defeat a One Nation style candidate who might have a reasonably good primary vote but be disliked by all other parties. And also it provides slightly more room for parties with similar views to compete with each other. For instance, the Greens and Democrats situation in the early 90s, though not as much room as the current system. Just checking the sound quality.
Excuse me, Dr. Bonham, we are having a little a problem with your line there. Just take advice from
We'll call him back on the mobile.
All right, we'll call you back, Dr. Bonham, in a moment and see if we can get a better line, if that's all right with you.
Okay.
So we'll just be one moment.
Okay.
Right, move to questions. Move to questions.
Shouldn't we have his statement?
Oh, no, we can come back.
All right.
So let's move to questions.
All right. Well, look, we'll come once we've established a better line with Dr. Bonham. We'll take his statement at that time. In the interim period, we will move on to questions and obviously provide Dr. Bonham with an opportunity to be asked questions as well once we have a better connection with him. All right. So we'll kick off with questions. I'll start as chair. So just a couple of questions to Mr. Professor Green. You mentioned in your statement that the current system is, or the change rather, would be weighted towards those who campaign for votes and weighted against those who campaign for preferences. Could you just expand on that a little and just explain what you meant by that, please?
At the original J-scheme hearings, there were two broad brush approaches to dealing with this. One was the path which has been taken, which is moving down the path of optional preferential voting. The other path was to move down the idea of some sort of threshold, which for a variety of reasons is not the path that's been followed. Both of those approaches do one important thing. The current structure of the ballot paper assumes that every sequence of preference by voters, all those preferences are equal as far as the vote is concerned. Their first preference, their second preference, their third preference, the weight between them is all equal, and the way the votes are counted treats each of those preferences the same value as the one before, just further down the list. But clearly that's not the case, because if people want to fill in for 110 preferences, there are clearly people there they don't know. The top of the list they may have strong views for, the bottom of the list they may have strong views against, but in between, what is their views? The second thing, so what you could do when you go into optional preferential voting is you're actually weighting it towards the preferences people have. If they don't give preferences, they don't have a preference. They don't have a view on that sort of area. So you're weighting it towards the higher preferences. Also, mathematically, as votes exhaust, because the ballot paper gets distributed down the list to where there's no more preferences, there is a larger pool of votes with no further preferences. So in that sense, it's harder for a party to come from behind because there are fewer votes available for a party to come from behind on preferences. So it weights it towards the first preferences, as does any form of threshold system, because it says, a threshold says you have to have a certain number of first preferences before you have a chance of getting elected. Whereas without a threshold, all first preferences, doesn't matter how many you've got, you can still get elected. So both systems work towards putting higher weight on preferences. Because of those features, a party that campaigns for votes is going to start with a higher first preference vote. A party with a higher first preference vote has got a better chance of getting elected because there are fewer preferences to come from behind and win. And as we also know from all elections in Australia, in Tasmania, pre-ticket voting in the Senate and in the state legislative councils, is that when voters have to give their own preferences, you do not get preference flows like you do under ticket voting. The lower a party's vote, under every system in Australia, the lower a party's first preference vote, the more random are their preferences. Because a party that hands out that doesn't poll well has generally not handed out how-to-vote cards. And if you don't hand out how-to-vote cards, you not only don't encourage people to vote for you, you also don't encourage them how to give preferences. So everything indicates that if you get rid of the ticket voting, is that the preferences become far less important because you have much weaker flows. If you have optional preferential voting, there are fewer preferences around to be counted, and therefore the system is weighted towards those who campaign, who hand out how-to-vote cards, have an influence on their first preference, and have an influence on how their preferences otherwise might flow.
And is your view that it is appropriate to make changes that seek to effectively value explicit votes that people choose to make, electors choose to make, as opposed to the preference type arrangements that exist under the existing group voting tickets?
On a ballot paper, the voter makes a mark indicating who they are voting for. They do not indicate who they're voting against, they indicate who they're voting for. Under the current system, we have 10 million ballot papers, all indicated one way or another who they're voting for. Some who've gone through and filled their own preferences are giving you a sequence of who they're voting for above somebody else. The current ticket voting arrangement, you have a ballot paper with someone who they're voting for, and then someone is inserting the preference ticket for them. Now, it may be that 10 million Australians are going in consulting the group ticket votes and consulting them before voting number one, but the evidence that has been made by people before this committee in the past has indicated that they don't think people are doing that, and I think I can't believe anyone in this committee believes that everybody goes and checks those tickets.
So your view is that the group voting ticket issue needs to be addressed?
The group voting ticket needs to be addressed. We saw what happened in New South Wales with dozens of tickets and parties that were created which were clearly the most famous one, the Marine Environment Conservation Party, which looked like a Green Party, but was actually directing preferences to the Outdoor Recreation Party and directed 60% of preferences that way. The Save the Forest Party, which did the same thing towards the Outdoor Recreation Party, the Women's Party. There were some clearly deliberate attempts to mislead voters with party names. There's been nothing quite as upfrontly misleading under the Senate system. But it's pretty clear that there are a lot of people who voted for tickets not really knowing where those preferences would go if those preferences were distributed.
Thank you, Professor Green. I might just clarify if we have Dr Bonham back on the line.
Apparently so. Can you hear me?
We can, loud and clear. That's a much better line. So apologies for that. Apologies for that, Dr Bonham. If you could please provide your statement.
Okay. I hope I could be adequately heard with what I was saying before. So on that basis, I'll just carry on from there.
Okay.
I was saying that there are some slight differences in terms of impacts between this model and the J-scheme model, but they're not great. And what I consistently find in modelling either model is that the party that seems to gain the most in seat terms based on votes actually cast is actually the Labor Party. And there's a logic behind this, which is that where you have ideological micro-parties, their preferences tend to go to either the Liberals or the Greens rather than Labor. Those preferences will flow less strongly under the proposed system. And so I find that there are several cases in the past where Labor would have done significantly better had this system been adopted, and yet it seems that they're most concerned about the small increase in chances of a coalition majority if the coalition does very well at an election. The other thing that was a major theme of my submission is the below-the-line voting issue. Now, I agree that we should be looking to liberalise below-the-line voting. I think that a lot of voters are quite angry about some of the pre-selection decisions that are made by the major parties, and that this is why we see, one of the reasons why we see such a drift away from the major parties, and that liberalising below-the-line voting would actually help. But it has to be practical, and it may be that if we have too high a rate of below-the-line voting, we may have unpredictable results, and there may be implementation issues. But I do find that in the debate so far, the case for making such small reforms for below-the-line voting has not been publicly made. Perhaps that case exists, but I think that there is a need to sell that case if so. I think that's all I really need to add to my submission, except to say that I did send through a slight correction because there were a few small errors in the double dissolution simulations. They're all in the system's favour. I can report they don't result in One Nation actually winning the balance of power in any parliament, and they also don't result in the Palmer United Party winning the balance of power by itself in the 2013 one. These were just errors in the comment section only, not in the numbers of seats.
All right, thank you, Dr. Bonham. I understand that those revisions have been received by the Secretariat. We'll now return to questions. Senator Conroy.
Thank you. Now, I noted recently, I think it was a week or so ago, Mr Green, you indicated that you believe the likely outcome would be of this reform would be an improvement for the Liberals, Greens and Xenophon. Did I misread your comments?
I'm not sure. I think they would have... Well, if you take the last election, for instance, the Labor Party wouldn't have won a second seat in South Australia and Western Australia. The Liberals would have won an extra seat in Victoria and Tasmania. And Senator Xenophon's team would have won an extra seat in South Australia. So the numbers depends which way you look at it. But I think the last election is actually rather hard to model because there were so many candidates on the ballot paper, and the sheer complexity of the ballot paper distorted from what would be a normal party pattern.
Have you seen the latest, I mean, there's been many, you may have seen them all, you may not have seen any parliamentary library analysis that I think Gary Gray circulated
I saw some.
I
haven't read it in detail.
Yep.
The person who wrote that did consult with me very strongly.
No,
I think our numbers...
No, he does make the point that he consulted with you strongly, so I'm sure you're roughly familiar with it. So I just wanted to see if you, given you consulted on this paper, he states, the obvious way to approximate the new system is to first look at how many quotas were achieved by each party as a primary vote. This will indicate how many seats the party is guaranteed to win and may account for 4 or 5 of the 6 vacancies at a normal half-Senate election. That seems fair?
Yes.
The remaining seats will be determined either by preference flows or by whichever party has the largest remainder after the full quotas are allocated to elected candidates.
Yes.
The only parties that could reasonably be expected to transfer preferences at sufficient numbers to elect another candidate are the larger parties, the ALP, the coalition parties and the Greens. Directing preferences consistently under the new system is only possible through how-to-vote cards, and only the larger parties have the infrastructure to distribute these to their supporters across the state. That all seems fairly straightforward. And then he goes on to suggest there are some limitations in the way that this is modelled. And whilst the 2013 Senate election is the most recent guide to the will of the voters, it was unusual in a number of ways which will likely not be replicated in future elections, most apparently the Palmer United Party and the Liberal Democrats. And I'm just reading, oh, he's gone. I always have to clarify for Senator Lanehome. The Liberal Democrats won substantial votes and won Senate seats that they were not likely to be able to replicate in future elections due to the loss in electoral support evident in recent polls and by-elections. Is that a fair
Yes, the system will advantage parties that campaign, distribute how-to-vote cards and therefore induce preference flows.
How many votes do you believe will exhaust by introducing the optional preferential voting system? Given you've seen what happens in New South Wales, when the system was changed, I've read figures of 80 to 90% cast a one, and there's no preferences after that. So what would be your estimation of the exhaust?
I can give you some precise statistics. Since the New South Wales system was introduced in 2003, the exhaustion rate was 84.8. In 2007, it was 83.4. And in 2011, it was 82.7. Now, that was the number of ballot papers of everybody else distributed and exhausting at the final count. It's, unless you actually go and look at the actual ballot papers, it's rather difficult to get the exact detail. But for the last election, I did get hold of the actual ballot paper details, and it's roughly the same number. 83% of ballot papers had only a single one above the line. There were 15.3% had above-the-line votes with preferences, and there was 1.7% completed below the line. I should say in relation to that, because the New South Wales ballot paper says just vote one. If you want to, you may go on and do something else. I will point out a different ballot paper, which is the ACT Legislative Assembly ballot paper, which has roughly the same, something similar to what would be on the Senate ballot paper. It says number 7 boxes from 1 to 7 in the order of your choice. You then may go on and number from 8 onwards. They only get about 2% with less than 7 preferences. So a ballot paper that says number up to that...
So 83% that just cast a 1 sounds pretty close to first past the post voting system.
That's in New South Wales, but if the ballot paper instructions said something else, what would be the difference? And these ballot paper instructions produce a very different result. I would be I would think more than half of ballot papers would have preferences if the instructions say 1 to 6. And the evidence, when I'm doing some research on...
At what point would you say that you've actually introduced a first past the post voting system? Is it 50%? 60%, 70%, 80%. I mean, you could argue what you've advocated in New South Wales has led to a de facto first past the post
Well, I don't use
system.
the word first past the post
I'm sure you don't.
in relation to this, because it's still a proportional system. First past the post carries all these stories about what happens in Britain or what happens in America in single-member electors. What it is becomes a PR system with a highest remainder. Is the first seats are all filled with full quotas, and the last seats are a highest remainder. Yeah. And so it's technically it's the highest remainder system. But it does make a difference, because the last 2 elections in New South Wales, it wasn't a highest remainder system. The last 2 elections, the last seat was determined by preferences. If it was first past the post, then Pauline Hanson would be a member of the New South Wales Legislative Council today.
Thank you, Professor Green. We're up to the next allocation of time, and that is to Senator Rhiannon.
Thank you for the panel. And Mr Green, you'd be aware that your name is often used to argue different cases. So I thought it would be useful to ask you, as some have argued, that the proposed Senate voting reform system that we're considering will deliver coalition Senate majorities. What do you think of that claim? And is it your view that the proposed changes will basically create a fair system and a fairer system than the current one?
The Senate is a proportional system. If a party wins a majority of the vote, it has a chance of winning a majority of the seats. So for someone to say, can you guarantee the coalition will never win a majority? No, I can't. If they win a majority of the vote, they may win a majority of the seats. Under more normal voting patterns, the coalition doesn't get a majority of the vote. I think I counted up, there's less than half a dozen instances in the last 25 years of them getting to 50% in their own right in any individual state, which say at a double dissolution where you're more likely to get a majority than a half Senate, that's the only time you'd sort of start seeing it being a chance. It's much more likely the coalition will win 6 seats at a double dissolution or 3 at a half Senate election in each state. But I would point out that during the Howard government in 1996, in 1998, and in 2004, they won 3 of all the vacancies in 3 states under the current system. So all I'm saying is it would tend to produce the same thing as the current system.
Yes. Senator Conroy, Senator Rhiannon. Thank you, Senator Rhiannon has the call.
One institutionalises it, and one is a random event.
Senator Conroy, Senator Rhiannon has the call.
I'll just say, under the current system, what you can do is you can engineer preference deals to stop the system delivering a proportional result. Because if you can take a party with a very low vote and deliver them victory, you distort the proportional result.
But also, in going back...
Thank you, Senator Conroy. Senator Conroy, please don't interrupt Senator Rhiannon, who has the call.
Going back, didn't you say in your response earlier that if under the change system, Labor would have picked up a seat in South Australia and WA?
Yes.
Yes. So, yes. So this statement that the coalition would be winning forever and ever, I think you're emphasising that it obviously depends on what the results of the elections are, of how they run their election campaign and what the vote is that comes in.
Changing the numbers to 6 per half Senate election in 1984 has created the situation where the Senate is always much more likely to be deadlocked, with one party if it does well at an election, winning half the seats, or in the case of the Howard government, it won half the seats 2 elections in a row because it won 2 handsome victories. Now, back in the 1950s, when Tasmania had a series of deadlocked parliaments because they were electing 6 members per seat, the solution was to go to an odd number, and then you don't get deadlocks in the same way. The Australian Parliament went the opposite way in sort of virtually deadlocking the Senate and making it very difficult for one party or the other to ever get a majority again in 1984.
Professor Williams, could I just ask, I just wanted to clarify to understand more thoroughly your comments, because the below the line issue is incredibly important. Are you saying that when voters cast their vote, the ease or difficulty should be the same above the line or below the line, so that it doesn't force voters to vote above the line or just go along with the selected order of candidates recommended by their preferred party? Is that the essence of what you're saying?
That's certainly one of the major arguments, yes, that a voter should have a free choice as to whether they want to vote for a party or a candidate, and that the system should not be structured so as to make one of those, particularly candidate voting, so onerous that it puts it beyond the bounds of practicality. And my point is that that's an ill-designed system, and hence that's why this committee reached a different conclusion. And as to how that relates to the potential constitutional issues, as Malcolm McKerris has indicated, the Parliament must design a system that is directly chosen by the people, a system that appears very much weighted one way rather than the other, that is directing people away from voting for candidates, is something that would raise some additional constitutional issues.
Thank you. Mr Bonham, could you elaborate? I think that you have been advocating to ban Just Vote One how to vote cards. Could you elaborate on that, please?
Yes, in states that have savings provisions, for instance, the ACT and South Australia, there are restrictions on advising voters to use them, because this can be used. For instance, you could run a siphon party that pretended to be a Green party but wasn't, and run a Just Vote One campaign for it, and it would then steal votes from the Greens. So it's important to strike a balance here with freedom of speech and discussion about political matters, including the quality of the electoral system. But I have recommended in my submission that it should not be allowed to issue a how to vote card that recommends that voters vote in a manner different to the instructions on the ballot paper, and that it should also not be allowed to encourage people to do this, or to publish an advertisement that draws people's attention to the fact that they can do that. Basically, the idea should be that people will just vote one above the line, but voters should not be encouraged to do that, because if voters are encouraged to do that, you may get higher exhaust rates than otherwise, and those may be distributed unevenly between different parties. We have seen in the ACT that the rate of people just voting one and then exhausting their preference is very low.
All right, thank you, Mr. Bonham. No, Senator Conroy.
Because you ride a bike, you might be a Green. I ride a bike, and I'm certainly not a Green.
Thank you, Senator Conroy. All right, we now move on to the time of the allocation for the crossbench senators, and I call firstly on Senator Day, and I believe that Senator Muir may also have a question during this block as well.
Thank you. My question is to Mr McKerris. If, as has been stated, that group voting tickets and so-called preference harvesting are such a problem, are you saying in your submission that it would be better to give voters an easier alternative, like 1 to 6 below the line, rather than risk or allowing up to 3 million votes to die or to exhaust? Is that the basis of your submission?
Essentially what I'm saying in my submission is the current system, which has been successful for 30 years and has given the fairest results of the 5 electoral systems ever for the Australian Senate, has a virtue, which is that it produces diversity. That is its virtue. However, I believe that principle should prevail in these things. Now, I've asked Anthony to state his principles, and he did so in his recent blog, and he said basically, the elector has a right to know where his or her vote is going. And I agree with that. But I would phrase it differently. The elector has a right to know where his or her vote is going in a candidate-based electoral system as commanded by Section 7 of the Constitution. That's my first principle. Now, on the question of that, I would have to say that you're likely to get a huge exhausted vote, and that the reform I favour for the long term would not be much good for your party. I encourage you to challenge this dreadful piece of legislation in the High Court, but I'm the first to admit it wouldn't be much good for your party because it would have that defect. As I see it, the current system has a set of virtues which has made it the best and the fairest system we've ever had of the 5 electoral systems we've had. My alternative, which is based on principle, has the advantage that it is principled. The present bill, in my view, falls between those two stools. It is the worst of both worlds. Because it is the worst of both worlds, I cannot see how I could do other than oppose it, and oppose it as vigorously as I can, and encourage senators to oppose it as vigorously as they possibly can, to do everything they can to delay it. And if it passes the 2 houses of the Parliament, when it gets the assent of the Governor-General, I urge a senator, or more than one senator, to challenge it in the High Court, because although it may be that the senator who does the challenging would be aware that it's not going to be much good for his party, I still think that principle is important in these things, and I argue that my statement is based on principle. I'm not interested in all these calculations about whether Labor would have won a second seat in Western Australia in the re-election and that sort of stuff. Of course, there wouldn't have been a re-election. But I'm simply not interested in any of that. I simply say, have a system based on principle, have a system which is obviously accords with the constitutional commandment of Section 7, have a decent system. It'll get a good reputation. It will get a good reputation. The people will appreciate a system based on principle. Now, after that, I say, let the chips fall where they may.
What do you say
I'm just not interested in all this party advantage talk that people are going in for.
But what do you say to my part, the people who vote for my party, who say they're very happy to delegate the distribution of preferences in whatever is the best interests of the particular party?
Well, I do admit that that is in practice the case, yeah.
Senator Muir, if you have a question.
Thank you. I'll be as quick as I can. My question is for Professor Williams. If you wanted to take power from parties to give it to voters, would you allow optional preferential below the line?
Look, my preference has been traditionally for full preferential voting, but I recognise that that's not the recommendation of this committee, and I do see as acceptable method to go for optional preferential voting below the line, as you say, yes, and my preference would be for that to be in parity with above the line. That is, number at least 6 boxes above or 6 boxes below. I think it's easier to educate about that. I think also that is a system that looks like it's not designed to satisfy the needs of political self-interest, but indeed respects fully the capacity of voters to cast a vote in accordance with their preferences.
So that would really empower the voter to choose where their preference goes.
That's right. And for me, I think designing a system should be beholden on Parliament to design a system that is geared towards giving voters the maximum opportunity to cast the vote that best reflects their preferences. And I think optional preferential below the line is a perfectly acceptable way of doing it. For me, I think the only argument at this point that really ought to get in the way is if the Electoral Commission can't implement below the line prior to the election. And of course, no evidence was given on that this morning. If that is the case, I would put to the committee that the least worst option is to say, well, at the very least, it should be legislated for now, so we're confident that we will have the below the line change for the next election. But we should not proceed with this change now without also legislating with some certainty that that system will be introduced when we know the Electoral Commission can properly implement it.
All right,
I agree.
thank
so
you.
Why do you think the government ignored the JSCM recommendation to have optional preferential below the line?
Look, I really have no knowledge. I've searched through the papers on the public record. I can find no justification for that, and it does disturb me because I think that that was a lengthy and effective process, and I think in the absence of a clear, compelling justification, particularly given the extraordinary expedition involved in this bill, that surely the appropriate thing is to follow the path that that committee has, I think, rightly identified.
Thank you, Mr. Williams. Thank you, Senator Muir. We've moved on to the next round of questions. Which is to the coalition. So I will.
The witnesses aren't allowed to answer questions if you're outside the time.
Well, that's not correct, Senator Conroy. We have a time allocation.
Mr. Green just attempted to answer a question and you stopped him.
The question was not addressed to Mr Green, and we move on to the next,
You're not allowed to have any
next round of
witnesses,
questions.
crossbench senators and
So,
ridiculous.
Senator, thank you, Senator Carr. All right, so my question is to Senator Williams, to Professor Williams rather. Professor, could you just outline, please, the issues as you see it with the group voting ticket concept as it exists in the Senate voting today? I believe you've previously written on this issue, and just explain what your concerns are about the current operation of the system.
I think, put simply, as this committee well identified, the current system is one that enables parties and not voters to determine the flow of preferences. And that's not a good system, because it may be that parties direct preferences to flow in a way that is indeed the opposite to what a person would see as their true voting intent. And I accept the point that some people may wish to vote in accordance with how a party sees it as their most advantage, but I think the way to deal with that is give them a how to vote card and enable a person to mark their ballot as directed by the party. But I don't think the group voting ticket is acceptable, and I think very clearly this committee has identified the reasons for change.
Do you think that it's likely that the average voter under the current system, when they vote above the line, has an understanding or visibility of what takes place with the allocation of those preferences?
Look, as Anthony Green has indicated, the answer is clearly not, and the evidence suggests that strongly. The practicalities are so difficult in doing so, and look, I can simply say, as someone who follows these matters very closely, going to vote as I did last time with my 3-year-old in tow, I'm actually working through those matters and getting the time to number 110 boxes below the line. It's impossible, and in fact the system is designed such that people do not have a fair opportunity, I think, to cast a candidate vote.
And could you, Senator Conroy, the call is not, Senator Conroy, the call's not with you, thank you. With the, obviously some contentions are made that there is something positive or appropriate about the existing system and the allocation of preferences as the group voting tickets currently do, you would obviously disagree with that.
Look, I think I start from the position of not trying to reverse engineer a result for any party, but simply I think it should reflect the will of the people to the maximum extent possible. The system does not do that at the moment. It enables parties and not voters to determine preferences in a way that can lead to outcomes contrary to their actual voting intention. And I simply think that should be changed. The committee has identified a straightforward fix. There's some ways that needs to be further amended. But if that occurs, then I think that, yes, it's an important and worthwhile change.
Thank you. Mr McHarris, I think from your comments in your submission, and please correct me if I'm wrong, but I think you suggest that there's been a problem with the Senate voting system for some time. You go back, I think, to 1984. Is that correct?
Yes. The system is unconstitutional. It is.
And has been since 1984, in your view?
Yes. The trouble was that look, this article is the best exposition of my position. I didn't actually write it, but the fact that it's written by somebody else is its great virtue, actually. But seriously, you should look at this article. The fact of the matter is that Mr Mackenzie, whose name was Cyril John Mackenzie, was an independent candidate for Queensland at the 1984 half-Senate election. Now, because people instinctively knew that this was an improvement on the old system, because people instinctively knew that this reform made in 1983-84 was, if you like, noble in its intention, nobody thought of the idea that it was unconstitutional. Well, I thought of it, but the point is I don't matter. But because nobody thought about it, and because people realised that this really was a noble piece of legislation, it hadn't fired anybody up until Mr Cyril John Mackenzie, this ungrouped candidate for Queensland who eventually got 84 votes from the right-hand position, he suddenly realised that this was obviously unconstitutional. So he took it to the High Court, conducted the case himself. Now, we all know perfectly well that to have a decent chance in the High Court, you can't conduct the case yourself. You require quite substantial amounts of money to get all the good QCs and all that sort of thing. But anyway, he conducted the case himself, and Chief Justice Sir Harry Gibbs was asked, in effect, just a few days before the election, am I, Chief Justice Sir Harry Gibbs, going to strike down this new system 5 days before polling day? Obviously not.
Yeah, all right.
So what you do is you write a judgment which shows clearly, I, Sir Harry Gibbs, hate this new system.
Yeah, so just to be clear...
I, Sir Harry Gibbs, however, I am sympathetic to Mr. Mackenzie.
Okay. So Mr.
But I, Sir Harry Gibbs, I can't just bring myself to invalidate this first election under this new system, so therefore he resorted to all the legalistic trickery to constitutionalise the unconstitutional, and ever since then, because the system's worked so very well, and for all these reasons I mentioned, he hasn't... It's not been revisited, but it should be revisited.
Okay, thank you, Mr. McCarroll. So just to be clear, and just finally, and I'll give the call to Senator Conroy, your view is that every Australian election since 1984 in the Senate has effectively been unconstitutional?
Yes, that is my view.
Okay, thank you.
That is my view.
All right, so I'll give the call now to Senator Conroy. Thank you.
Look, I'm just wondering if you could show me where you've tested 12 million Australian voters' views, and of them 96% have voted above the line, that they really were duped, and that they didn't make a conscious decision to vote above the line, knowing there's a registered party had a vote card, versus voting below the line. I was just wondering if you could just point me to where the evidence of that is.
Well, I think the one way to look at this is that some of these...
No, I didn't say look at it. I said, do you have any evidence that shows...
I have what I think is evidence.
Okay.
Okay. Some of these preference deals are very difficult. Someone filling in a ballot paper below the line would be very lucky to get the same preference sequence as is lodged above the line. Voters below the line are much more...
Isn't that why they've voted below the line? Because they want to vote differently? I mean, it's like... To me, a bizarre argument.
I'll explain.
They've chosen to vote below the line because they don't want to follow the party.
I'll give you the numbers. The last
Thank you,
Victorian election, last Senate election, where Senator Muir was elected, there were two senators, two from Labor, two from the Coalition, elected initially, and then towards the end of the count, the Greens were elected, and then Senator Muir defeated Senator Kroger from the Liberal Party. Towards the end of the count, there were only 5 parties left in the count: Senator Muir, the Greens, the Liberal Party, Palm United, and the Australian Sex Party. For Senator Muir to be where he was at that stage, he required the preference tickets of 20 different parties. So 20 parties with much lower votes had all delivered 100% of their ticket to the Motoring Enthusiast Party. If you look at the below-the-line votes, there was only 6% went to Senator Muir. 37% to the Greens, 21% to the Liberals, 13% to Palm United, 21% to the Australian Sex Party. People filling in their preferences in their own way sort of went to the parties they knew.
But they made the choice to vote below the line so they could do that. 100% of people who voted below the line made the choice they didn't want to follow a party ticket.
And how many people would have made that choice if they didn't have to fill in 93 numbers?
So you object to the number of people...
The choice is asymmetrical.
Below the line, you don't have to be a registered...
You have been herding people above the line for the last 3 decades by making the choice of how to vote asymmetrical. You can walk in, or you can vote one, or you've got to fill in every box below the line. It's a herding process to make people vote above the line. And what those numbers show is that what they're doing, what the parties meeting in their room are doing with their preference tickets is not at all anything like what the voters
meeting in their room and then publishing it so it's available to anybody who wants to look.
In Western Australia, if you wanted to know where your ticket vote went, you had to know what order the Australian Christians and the Shooters and Fishers Party finished. And they were the 9th and 10th placed candidates that flip-flopped and determined the last 2 seats. You could not determine which preference your vote would go to if you voted on a ticket, unless you also determined what order those 2 parties were in. And neither of them were in the race for the final seat. The model is so complex and so dependent on the orderings in which candidates are moved. And in that case, where Mr. Dropulic was elected, he got preferences from 21 parties. Now, I think 18 of them were at the relevant point. 85% of, he got 100% of the 18 parties and 15% below the line. So the 2 candidates who were elected from the lowest vote were the least known of all the candidates for people who filled in their below-the-line vote. I don't think it was a choice that the voters made to vote below the line because they didn't like the tickets. I'm saying the choice that's being offered at the moment is so asymmetric that it forces people, it herds people into voting above the line.
And so you think a fairer system is one that sees 80% of votes exhaust?
That is the New South Wales system with a just one. These ballot papers indicate vote 1 to 6.
No, let's be clear.
Senator Conroy, I think Mr Green's answering your question. He's answering your question.
No, he's not answering my question.
He is answering your question.
Even you believe that 50 to 60% will exhaust. Okay. Now, if parties start campaigning, as they're now legally going to be allowed to do, say, just vote 1, then you'll get the same result, 80%.
I would point out if parties had so much effect with just vote 1 that either Lawrence Springborg or Jeff Senior would be Premier of Queensland today, because 1 in 5 of the seats won by Labor at the last Queensland election were won on preferences. So optional preferential voting is not de facto first past the post.
Just coming...
Senator Conroy.
So I'm just coming... thanks. So I'm just coming back to what the outcome is. And you had a lengthy conversation about getting majority. It's probably, I just define a majority in 2 different ways. One's a positive majority and one's a blocking majority, being 38. 38 requires 42% of the vote. So you don't have to win the ballot, you don't have to win the election, you just got to be able to get the closest under your system to 42% of the vote to get 3.
Yes, as it is now.
And we've agreed the analysis, you've agreed with the analysis after the person who wrote it consulted with you, so I would hope you would, that the remaining seats will be determined either by preference flows or by whichever party has the largest remainder after the full quotas are allocated to elected candidates.
Yeah, there are some situations...
And you went on to say it's much more likely the Liberals could get 38. Those, I think, were your exact words. I'm happy to check with Hansard, but I think those are your exact words.
That's the current situation as well.
All right. Thank you, Mr Green. Senator Conroy, your time's elapsed. Senator Rhiannon.
Thank you. With regard to this idea that people would be out there with just vote 1 cards, is there any incentive for people to do that, considering for the last spot, preferences most likely will be needed? You've given the examples from New South Wales. So is it likely, Mr Green, that people would be issuing vote 1 cards? Is there an incentive to do that?
I did some modelling. There has been some attempts to try and encourage people to give preferences in the New South Wales Upper House. It doesn't seem to have been particularly effective. At the last New South Wales election, the highest rate of preferences was by the Greens, who I think, I can't quite find my numbers here, unfortunately. Parties have tried to influence. They've handed out how-to-vote cards with 1s and 2s or 1, 2, 3s. It's not been very effective at encouraging people to do that. I think there are some differences. The New South Wales ballot paper says just vote 1, so the instructions say that. The New South Wales ballot paper is not an attractive ballot paper, even with the reforms. It's still a very large, what I like to call a mutant lotto form by the look of it, because the sheer number of candidates that must be shown below the line. I think it's in the interests, given that there's a higher quota, and therefore the last spot is up more for grabs because you've got to get to a higher level of vote. It is in the interest of parties to be trying to encourage voters to give preferences. There may be some parties that want to punish another party by advocating 1. That's up to the Parliament to decide how it wants to deal with that, whether it wants to stop just advocating 1.
So is what you're saying is that the parties are serious, parties who give out how-to-vote cards, who are trying to get candidates elected, would have an incentive to give preferences?
It is. Some parties may find that it's more important that they have a formal vote cast. Their first preference may be very large, their second, third, fourth may be much smaller. I think it's up to parties to decide how they do that. But certainly I think there's a lot more encouragement in this for parties to indicate preferences, to try and encourage voters to give preferences, because their preferences may be important. If it's a party which is just short of a third quota, then it's probably their preferences aren't going to be distributed.
But they won't know that until the election day.
They'll have some rough idea, but even if they only...
It's a risk.
Within 1% or 2, it'd still be in the interest of all parties to indicate preferences.
Thank you. Mr Bonham, the issue about other parties and the percentage comes up, and I was interested in your comments on this. Can you elaborate on the idea that while the collective category called other parties may have won 23% of the Senate vote in 2013, it is a false logic to argue that collectively that should be rewarded with 23% of the seats for micro-parties. Is your contention mainly based on evidence that many of the micro-party voters preference Labor, Greens or the Coalition ahead of other micro-parties?
Yes, I had a look at what micro-party voters do in the House of Representatives where they don't have the guidance of above-the-line voting, and I found that quite substantial numbers of micro-party voters send their preferences to Labor, the Coalition or the Greens, even when there are other micro-parties still left in the count that they could send them to instead. And the reason for this is pretty obvious that micro-parties are a diverse bunch. You know, some are left-wing micro-parties, some are right-wing micro-parties, some are unclassifiable. Some of the left-wing micro-parties hate the right-wing micro-parties and put them last and vice versa. This sort of idea that there's this monolithic group of 20-odd% of Australians at the last election, although that was higher than normal, who want any alternative to the major parties, whatever it is just a complete furphy. And on that basis, arguments that this system would result in underrepresentation of other parties, I just don't think are sound, because they're not entitled to that level of proportional representation in the first place when they're not all the same thing, and when you can't have everybody who gets 0.5% of the vote in the Parliament.
All right, thank you, Mr. Bonham. Senator Rhiannon, we have.
Can I just, I found the figures I was after for Senator Rhiannon's questions.
questions.
I've taken all the above-the-line preference ballot papers for the New South Wales election, and again on the basis that they only indicate one. But of the Coalition's votes, 5.5% of all their votes exactly followed the how-to-vote card, which is one Coalition, 2 Christian Democrats. The Labor Party had a sequence of 4, 1 Labor, 2 Green, 3 Animal Justice, 4 Australian cyclists. 4.2% of Labor voters exactly followed that, and 2.8% just went 1 Green. There was a substantial, about 5% of Green voters went Green 1, Labor 2. The party that had the strongest incidence of people following the how-to-vote card was the Christian Democrats, who had 11% following 1 Christian Democrat, 2 Coalition. So the numbers are not very high, but that's in a system where there's a very high exhausted rate, and it's not indicated to give
Thank
preferences.
you, Professor Green. Now, we're just on time, but we started a couple of minutes late, so I'll enable the crossbench to have a few moments for questions. Senator Xenophon.
Just one question to Professor Green. Are you able to comment on the likely difference in outcomes, electoral outcomes, if the bill is amended to allow an optional preferential vote below the line of, say, a minimum of 6 or 12 boxes? And would you see any practical or technical difficulties to effect this?
I don't see it would change outcomes even before ticket voting was introduced. 95 to 98% of people voted 1 for the top of the party ticket and went straight down. People have always tended to vote straight down the ticket. It's 30 or 40 years since we've seen such much variation from those figures. I don't think enough people would do it below the line to really affect outcomes. In Victoria, where it is allowed to vote 1 to 5 optionally below the line, they're only getting 6.1% voting below the line, as opposed to 2.7% in Victoria at the federal election. So it's only a doubling of the numbers. But that, just because the numbers are small, doesn't mean that you shouldn't give voters that right, because you're actually limiting their options. And I can't see that it's technically that difficult for the Commission to do. And the numbers that he quoted earlier was that increasing from 3 to 5 the number of errors was only saving about 4,000 extra informal votes, which is quite a tiny number across the country.
All right, thank you, Senator Xenophon. I'll give other crossbenchers an opportunity to ask a further question if they'd like to.
Yes, Mr. Green. In the New South Wales Legislative Council elections, which you described as an improvement from the prior system, do you think it's optimum?
Look, I think there are confusions created by the fact that they have to put 15 candidates for every group, which makes a particularly ugly ballot paper. I still think they need to tighten up their rules on getting on the ballot paper. There are a couple of people who put themselves on the ballot paper last time who did not campaign and got less than 100 votes for their entire ticket, because they clearly didn't seem to understand the rules of nomination. And that caused all sorts of complications about whether there was another box above the line, and it caused a problem with their I-voting system because there was confusion over which groups had blocks and which didn't. For New South Wales, because it is such a large number to be elected 21, I think there are fairer ways to allocate the seats, that the last seat allocated on the lowest quota is not the best way when you're electing that many members. I think...
What's the highest remainder necessary to get elected to the Legislative Council in New South Wales?
Off the top of my head, I think one of the candidates has been elected from 1.9% under the current system.
What do you anticipate will be the highest remainder for a party to get elected for one of the 6 Senate seats in a state, half Senate election?
I think a good example would be to look at New South Wales Senate election in 2001, when the Greens, the One Nation, the Greens and the Australian Democrats all ended up between 3.5% and 4.5%. And there were no preferences floating around from the major parties. So one of those 3 parties was going to win the last seat. As it was, the Greens won the last seat. They came up on a strong flow of preferences. That was actually an interesting election because there was a gentleman called Mick Gallagher from a party called No GST who was almost elected because of some side deals the Greens had done to try and improve their position. In the end, he dropped out along the way.
Thank you, Senator. Thank you, Senator Lyon.
And
Senator Lyon-Helm has the call.
In that situation,
Senator Conroy, please
I would imagine
don't interrupt the witness. All right, thank you.
That's the situation where you may see a candidate elected with only 5 or 6 or 7%.
Senator Conroy, Senator Lyon-Helm has the call. Senator Conroy. Senator Lyon-Helm has the call.
So if a party's sort of first rung on the ladder, is 5 or 6%, I think was the number you just said. And you also regard it as necessary that they campaign, and your description of campaigning means handing out how to vote cards. Is that correct?
It's one of many. Some parties don't. For instance, the Christian Democrats and the Shooters and Fishers Party do much of their campaigning directly to their audience through licensed firearms clubs, through Christian groups and like. So they can do a different sort of campaigning in that way.
But the question, I guess, is that if you're going to do preference deals with other parties so that your supporters know that if you don't win yourself, if for a party to say to your supporters, if we don't win, we would like you to vote for your vote to go to another party. The only way to communicate that is by how to votes. So they're going to, for an entry level, for a party to get onto the first rung of the ladder and win a seat in the Senate, they would need 5 to 6% of the vote and to hand out how to votes. Is that right?
Yes, well, they'd need that to get the votes in the first place. If you want to get votes, 5% is the rough figure I've used. It could have been lower depending on how the vote is divided.
So you don't like the ACT system where how to vote cards are not permitted? Or the New Zealand system, similarly, not permitted?
I don't have a problem with banning how to vote cards, except if you've got compulsory preferential voting in the House, you're guaranteeing to put up the informal vote. If you had optional preferential voting, I think you can quite happily ban how to vote.
All right, thank you. The time for those the questions has elapsed, as has the time for these witnesses. Can I please thank Professor Williams, Professor Green, Mr. McHerris, and Dr. Bonham. Thank you, gentlemen, for your testimony before the committee today.
I apologise for the shortness of time you've been given.
We'll now be suspending the hearing for the morning tea break, and we will reconvene shortly. Thank you. We're just...
Mr Chairman, I've got a point of order.
Yes, Senator Cunningham.
I intend to contribute additional comments into a dissenting report. When will the Hansard be available for the evidence that's been presented today to allow us to draw upon the evidence?
3 p.m.
3 p.m. I'm advised by the Secretariat, Senator.
Thank you.
Thank you. All right, so we'll move on to our next part of the inquiry, which is to welcome our next witness, Mr Tony Nutt, the Federal Director of the Liberal Party of Australia. Thank you for your submission to this inquiry which is labelled number 19. Now, for the benefit of Hansard, would you please state your full name and the capacity in which you appear before the committee?
Anthony Basil Nutt, Federal Director, Liberal Party of Australia.
Thank you, Mr Nutt. I now invite you to make a 3-minute opening statement.
Briefly, Mr Chairman, the Liberal Party has provided submission by way of letter to you and to your colleagues. The letter summarises the position of the party and I think is reasonably clear, so I don't think it's necessary to speak for 3 minutes. I'm sure your colleagues have questions, other than to say that the Liberal Party supports and respectfully recommends to the committee the legislation recommended by the government. So.
Thank you, Mr Nutt. As with previous witnesses, we'll rotate the call for periods of approximately 5 minutes, commencing with myself as chair. Mr Nutt, could you please provide your view on the existing use of group voting tickets and any issues that you see with the way the system operates at present?
Mr Chairman, the report in 2014 of the Joint Standing Committee identified on a bipartisan basis a number of serious failings with it. It's summarised in the note I've provided to the committee. Both the work of the committee, the Liberal Party submission at that time, the work of other parties, including that of the Australian Labor Party, others, identified the problems with group voting tickets. If I can quote the Liberal Party submission at the time, in recent elections it has become clear the current electoral arrangements have loopholes which are being exploited to distort the intent of Australian voters through complex and hidden preference deals. The forward to the final report by the then Chairman, now Speaker of the House of Representatives, Honourable Tony Smith, said, quotes, while such gaming of the system is legal, comma, it has nonetheless distorted the will of voters, made Senate voting convoluted and confusing, and corroded the integrity of the electoral system. Without seeking to quote numerous other examples, if you examine the submission made by others, including significant other political parties, similar points were made. That's where the Joint Standing Committee found. And if you look at the work of people like Anthony Green and others, going back to him identifying the incipient problem back in the mid-90s, and then it developed over time, particularly in the New South Wales Parliament, where there was remedial action by Bob Carr's government. So the issues built up over time, came to a head in some ways after the 2013 election. Joint Standing Committee looked at it. I think the basic deficiencies in the system, which was lawful, but there's still deficiencies in the system, have become apparent, and there's been a range of remedies discussed. The government has now put a remedy before the Parliament for consideration.
Thank you. And so do you believe that the proposed changes will increase the transparency of the Senate voting system and enable voters to have a clearer picture over where their preferences flow?
I do.
Thank you. Can I also ask you about the provision in relation to logos on ballot papers, where the bill provides that parties may elect to have their logo on the ballot paper? Do you believe that this is an appropriate provision, and what are your thoughts on issues such as ballot paper confusion and so on that perhaps has been seen in the past?
Well, it's going to be an optional provision, so it will be the party to decide if they want their logo, their registered logo, and there'll be a register, so there'll be some control over the material that's printed. I think that will assist parties, and I think it will assist electors, more importantly than parties, in identifying to whom they wish to give their support. So it'll be voluntary, there'll be a register to control any misuse of logos, and electors, if it assists electors in identifying whom they wish to support, that's a good thing, but it'll be voluntary and in the hands of parties if they wish to exercise that opportunity. I think a logo can help some electors in certain circumstances where they want that additional information, Mr Chairman.
Thank you. Mr Nutt, under the existing system of group voting tickets and preference allocations and so on, what is your view on the understanding of the average Australian voter into how those preferences are allocated and the mechanics of group voting tickets? Do you think that is widely understood by people when they cast their ballot?
I think that most people would have little detailed understanding of the group voting ticket process, and the effect of the group voting ticket process would be poorly understood, and the mathematics, the science, the internals of it would be poorly understood. And I think that the principal objective of the legislation and the principal objective of what the Joint Standing Committee was doing in 2014 and what people like Anthony Green have been talking about for years is to empower voters, and I think that's a good thing.
So that under the proposed changes, the voter themselves will have a greater say in the way those preferences are allocated?
Well, below the line at present, you've got full preferential with savings provisions, but above the line you've got one in the box. By making it 1 to 6, minimum of 1 to 6, that will enhance the voter's capacity to decide and not the decision-making of people like me to decide on their behalf. I think that's a good thing.
All right, thank you, Mr Nutt. I'll now pass on the call to Senator Conroy.
So your argument, Mr Nutt, is that for 30 years people have voted above the line and not had a clue what they were doing by voting a line, giving effectively saying, I trust the party to decide whether or not the 57th or 58th preference is 57 or 58? They've not understood that's what they were doing?
Well, that's not, with respect, Senator, a correct characterisation of what I said. I think I was asked about their understanding of the detailed mechanics of the system. So, of course, they've understood, 97% or so of people vote above the line, that if they put one in a box, for instance, they're supporting a party. Of course they understand that. They understand that they have an option, full preferential below the line, to either the numbers, alter the numbers that parties recommend in a particular party box, or vote more broadly across with savings provisions. But I think if we're talking about the detail, the particulars of how the group voting tickets work, the allocation of preference and the complexities of that, I don't think they have a good understanding of that, Senator.
And I've spent some time examining these issues over the many years that I've been involved in politics, not just in Parliament. I've probably only met 10 people who truly understand how to work and most of them have been in this room this morning, who actually have a genuinely full understanding of how that system would work. So I'm not sure anything has changed. When I started learning about it myself all those years ago, not that many people, and I'm talking small numbers, understood the full way that system worked. And I don't believe that's changed. So I accept the point that's being made that others have come in, and I characterise it when I have these discussions as, look, all that Glenn Drury's worked out was how to game the system the same way Tony Nutt and Gary Gray did for years. And they've got a group of people in a room and said, as long as you don't give a preference to the Greens, to Labor or Liberal, one of you in this room, I don't know which one of you, but one of you in this room will get elected. And has that been any really different to when you used to go and offer somebody, we'll give you your our fifth preference in return for your second preference, or we'll give you our ninth preference in return for your third preference.
So that's the system you'd like to keep going, Mr. Conroy.
Thank you, Senator Rhiannon. Senator Conroy has
Senator Rhiannon setting out the case of the problem that we've got.
Senator Rhiannon, Senator Conroy has the call. Thank you.
I'm just asking, that's essentially what's happened at the moment, but the total number of people who would fully understand the way the science and the maths works is a very small number. Is that a fair call in your experience?
The number of people who would understand, amongst general electors in the wider community, who would understand the detailed mathematics and processes of group voting tickets would be limited.
How limited do you think,
well,
in
I think
truth?
quite limited. So that's true. But the question before the committee, respectfully, Senator, is whether or not something that was put in place 30 years ago to attempt to reduce informal voting in good faith, it's developed over time. It's happened not only at the federal level but at the state level, and New South Wales is a very good example of this. And if you look at Anthony Green's work in this area, and I refer, for instance, to his essay on the drum, Hand the Power of Preferences Back to the People, Wednesday 11 September 2013, he looks at what was happening in New South Wales back to 95. So over time, certain practices have developed. You can track it. And over time, those practices have developed further and further. They've been enhanced by various practitioners in the system, if we want to use
Almost to your
antiseptic
level.
words.
They've almost become as good at it as you.
Well,
and Gary Gray.
Well,
thank you. Yeah.
I'm complimenting Mr. Nutt. That is a compliment.
Where is your colleague?
All right, thank you. Order, please.
I'm sure Mr. Nutt took that as a compliment.
I think if you could address the senator's comment in relation to the complexity of the system generally, Mr. Nutt, that might be the best way.
It's kind of you, Mr. Chair. I can assure you I'm far too old and ugly to worry about the odd flick on the way through. That's all part of the democratic process.
Well said.
So the point is that there have been developments over time. We've now reached a certain stage, and that stage has been addressed by the Joint Standing Committee. It's now addressed by this proposed legislation. And the question is it better to empower electors to make these decisions, minimum 1 to 6, or is it better to have party secretaries or registered officers making these decisions, including being able to split your group voting ticket? I think it's 3 ways. And to vest the power in people like me, and I think Gary Gray, who is an excellent National Secretary of the Labor Party, and I'm sorry to see him leaving the Parliament, a man of principle and competence, although a strong political opponent.
I agree.
I think in the practice is it better in the hands of the electors or better in the hands of officials? It's better in the hands of electors.
All right, thank you, Mr. Nutt. Senator Conroy, your time has elapsed.
Senator,
it's been nearly 6 minutes. Senator Rhiannon has
had my
the
6 minutes.
Thank you.
Thank you, Mr. Nutt. Some have argued that the proposed system of Senate voting reform that's set out in the bill will deliver the coalition Senate majority. Some have gone so far that it'll be locked in, and I acknowledge the interjection from Senator Conroy, because he is the main proponent of this, that forever there will be 38 coalition senators. Is that your analysis? Well, we're getting it on the record. It is Hansard.
Anthony Green's assessment.
Excuse me, Senator Conroy. Senator Rhiannon has the call. Senator Rhiannon.
Could you comment on that, please?
Sure. If I could, respectfully, Senator, if I could work out how Australians are going to vote in the future, I'd be on a desert island.
Senator Conroy, I'd ask that you don't interrupt the witness. Senator Conroy, I'd ask that you don't interrupt the witness. Mr. Nutt.
Thank you, Chair. It's, as I say, I take no offence at Senator Conroy. We're both vigorous participants in the political system. So you don't know, because it's dependent on what voters will do, and voters over time change their mind. Voters have elected Senator Dick Xenophon. Voters identified and began to support over time the Greens. Voters decided at a certain point not to support the Democrats, having earlier supported them. There is change in the political system. The Palmer United Party emerged at short notice and secured parliamentary representation. So electors have a funny way of making up their own mind, thanks very much, about what they're going to do. You can look at scenarios, but I always find scenarios at best, a sort of interesting intellectual discussion. I don't think, answering the Senator's question, that this change will advantage the coalition in terms of having some sort of locking in some sort of position. What it will do is advantage electors, so they'll be the ones making the decisions rather than people like me. But there's some open source material, speculation by academics, people like Anthony Green. There's speculation, I think Mr Gray said in his remarks in the House last week, that he'd had the Parliamentary Library look at some things. There's different debates, but I don't see any evidence that anyone's going to have any locked-in positions, and certainly in terms of control of the Senate.
Thank you. I mean, you would obviously be aware that there will be instructions on the ballot paper if the legislation goes through to number at least 6 boxes. There has been some speculation today and previously that some people may advocate a just vote 1. Could you expand on the likelihood of do you think that is likely to happen? Would there be an incentive for people to give preferences? Is there a requirement to put something in legislation to ensure that that doesn't happen?
Well, the Parliament's not yet decided the matter, but if the Parliament were to decide the matter on the basis of the recommendations made by the government, it would be the intention of the Liberal Party to recommend at least 1 to 6, because that would then be for the electors to decide whether they wanted to follow our recommendation or anyone else's. There's a savings provision at 1, and there's obviously the option to go beneath the line, beneath the line with the additional changes in the legislation that will reduce informals below the line from about 2% at the 2013 election to about 1%. So there's an enhancement below the line for voters in terms of ensuring that their votes remain valid, and there's an enhancement above the line, and certainly would be the intention of the Liberal Party to recommend at least 1 to 6. Who electors vote for will have a how to vote card. Greens will have a how to vote card. Everyone else will have a how to vote card, but it will be up to the elector to make that decision. I'm not sure that it's necessary to make it an obligation. I think the legislation as proposed is satisfactory.
Thank you. Thank you, Chair.
Thank you, Senator Rhiannon. It's now we turn to the crossbench questions. I give the call to Senator Day.
Thank you, Mr Chair. Mr Nutt, it's been reported that only yourself and the Prime Minister know when the election will be. Can you tell the committee when the election will be held and what role
Senator Day,
what role this legislation will play in that decision making?
Senator Day, that question is clearly out of order as it's not related to the provisions of this bill. I'd invite you to rephrase the question.
The witness wants to answer the question.
I'd invite you to rephrase the question.
Well, I'll rephrase the question. What role will this legislation play in the decision making of when the election will be called?
Senator, and I know you from a previous life, Senator, so you're a good and decent man. The news is that only God and Malcolm Turnbull know when the election will be, and neither of them have told me. Exactly when the election will be, seriously, Senator, Prime Ministers, Labor Prime Ministers, Liberal Prime Ministers, all Prime Ministers, they have discretion. My apologies, I'm interrupting that.
Senator Carr, order. Mr.
Thank
Nutt.
you. No, my apologies. I didn't wish to be discourteous to the committee. So Prime Ministers decide those things. They have a range of options. What are the options? They're options that are on the public record. They're set by the Constitution, by the length of the Parliament. They're all matters of public record. It's not black magic. Prime Ministers make decisions. I've worked for Prime Ministers who've made such decisions. Other people here have worked for or with Labor Prime Ministers who've made such decisions. So no one knows that.
The role of this legislation was my main point.
I'll get to that point, but you led with your chin, so I thought I'd respond.
All right, Senator. Senator Day.
Sorry, my apologies, Chair. Just to get back to the Senator's second point. In order for the Electoral Commission to make the technical changes they require to implement legislation, if it were carried by the Parliament, Tom in his team, the Electoral Commissioner in his team, need a period of some months. So it's coming into the Parliament at a certain time. They'll require time to implement it if the Parliament agrees to it. Assuming that happens, then it'll be in place for the next election. But that's a matter for the Parliament to decide and the Electoral Commission to implement if the Parliament so decides. There's a variety of constitutional opportunities before the Prime Minister. They're all on the public record. What decision he makes will be a decision he'll make at the time he makes it.
Thank you, Mr. Nutt. Senator Linehill.
Thank you, Chair. Mr. Nutt. We've previously heard this morning from Anthony Green that he supports the proposed legislation. Yes. He also concedes that it would require a vote of 5 or 6% and including handing out how to vote cards to get elected, the first ladder on the rung, and you've quoted him favourably. Is Mr Green a witness for the Liberal Party in the AAT in a case regarding my party's name?
Senator, I must take advice on that issue from the Secretary. Yeah, Senator, that's not relevant to this inquiry. I'd ask you to ask another question.
But what I would just say, Mr Chairman, just by way of passing, that unless I've missed something, Anthony Green is an independent commentator with the ABC, which last time I looked is not a lick-spittle apologist for my party.
Senator Lionhelm.
All right.
Working on it, aren't you?
Certainly not, Senator.
Order.
Senator.
Order. Thank you, Senator Carr. Thank
I
you,
knew I should
Senator
have brought
Conroy.
two Snickers bars, Mr Chairman, instead of just one.
Thank you, one and all. Senator Carr, thank you. The call is with Senator Lionhelm.
Thank you, Chair.
Sorry, Senator.
Mr Nutt is a big boy and can deal with the robustness of politics, I'm quite sure. Okay, now in the Senate rerun election in 2014, there were two preference whisperers operating on behalf of your ticket over there, the Liberals and Liberal ticket. They were Senator Ron Boswell and Mr Ben Morton. As a consequence of their activities and negotiating with my party, our votes were allocated to the Liberal Party when we were excluded. And as a consequence of that, Senator Linda Reynolds is there. Are you comfortable that my suspicion is that the vast majority of our voters would have been quite happy for our votes to have ended up where they did. Now, you're quite comfortable with the idea that probably those who vote for us in future are likely to vote one above the line, because that's where Mr Green says it's likely to end up, similar to New South Wales. So you're quite happy with that, notwithstanding what that will do for your votes in future?
Okay, well, at that time, I think I was the New South Wales Director of the Liberal Party, so I wasn't familiar with the detail of negotiations in West Australia. I know who Ron Boswell is, and Ben Morton was the State Director of the Liberal Party, recently retired and an excellent State Director. I will always be in favour of a process by which Senator Reynolds was lawfully elected to Senator for Western Australia. In the current system, people have discussions and negotiations and then are registered group voting tickets. I understand that, and you and other of your colleagues participate in that process lawfully. I think the question before the committee, respectfully, and before the government's proposal, is that noting various developments over time, trying to be courteous about this, it would be better for that power to be in the hands of electors rather than the hands of people like me. I think that's the big issue, allowing for other issues. That's the big issue, and therefore, if you empower electors, electors will make decisions. And frankly, sometimes parties will like the decisions they make, and sometimes they won't. But the electors will decide, Mr. Chairman.
Thank you, Senator Lionhelm. All right, so that concludes the time allocation for the crossbench. We have about 5 minutes remaining from this witness. Mr Nutt, I wanted to just ask you to expand a little on the issue of the multiple preference allocation tickets that can be lodged under the group voting system under the current regime. Could you just expand on your understanding of how that works and what a voter would have to do in order to understand how their vote would be allocated?
Well, in terms of a party, you can allocate, as I recall, up to 3 variants, and you can have discussions with other parties and other officials, talk about preferences, as Senator Conroy mentioned earlier, come to some understandings about what they will do and what you will do and how you will split the ticket and how you'll divide your group voting ticket. And that's quite a complex process, particularly where there's large numbers of parties present. And the flow of your recommendations, which are lodged and they are registered and then are enacted, have mathematical impact across the system. And the capacity of the individual elector is notionally there. They can go to the AEC website and they can look at all the registered how to vote cards, and they can look at the flow of preferences, and they can do a detailed analysis of that in their spare time. Should they happen to be a PhD in mathematics or something, they'll easily understand it, and then they'll be able to make judgments about whether the group voting ticket for one or another is represented their wishes, make judgments about that, or whether, for instance, some of the multiplicity of parties truly represents what they say they do. So just to give you an example, and I'll pick one from the New South Wales Parliament, if I may, Mr Chairman, so I'm not talking about anyone in the current Parliament or the current federal political system. I mentioned earlier that Anthony Green's been tracking this since about 1995. If you look at the 1999 state election in New South Wales, which was subsequently caused the Labor government there, Bob Carr's government, to make amendments to the legislation. Look at some of the parties there in 1999. And Anthony Green looked at what they did, what their voters did below the line, and where the ticket sent their voters above the line. The Marijuana Smokers' Rights Party directed preferences to Mr Glenn Drury and Mr Malcolm Jones. But of those who voted below the line for that party, 41% gave their preferences to the Greens and 12% to the Australian Democrats. The Gay and Lesbian Party, who Mr Green reminds us apparently had no gay or lesbian members, they directed their preferences to Mr Drury and Mr Jones, but below the line, voters directed 33%.
Order.
It's a matter of, I'm
Order.
referring, and I'll happily provide to you, Mr Chairman,
Thank you, Mr.
Mr Green's paper dated Wednesday the 11th of September 2013, in which he's done an analysis and he says this. They directed, the Gay and Lesbian Party directed 33%, their voters below the line directed 33% of their preferences to the Greens, 29% to the Australian Democrats, 12% to Labor. The Animal Liberation Party directed its ticket preferences to Malcolm Jones, but 44% of their below-the-line voters flowed to the Greens. The Wilderness Party, notice the names, the Marine Environment Conservation Party, the Wilderness Party, there's party after party, I won't be tedious. All of these parties, their actual voters attracted to the name of Wilderness Party, the Marine Environment Party, the Animal Liberation Party, the Women's Party / Save the Forest, names which might be indicative of perhaps a philosophical position or two. Their actual voters voted very differently than the directed group tickets. And just to, and I appreciate time is ticking, Mr Chairman, what Mr Green says, there is clear evidence that people who voted for the party below the line considered them to be environment parties and gave preferences accordingly. Full stop. However, anyone thinking that way and voting above the line found their preferences effectively stolen, not my words, and delivered to Mr Drury and to Malcolm Jones. So the point being that these processes can lead to a gaming of the system. The Joint Standing Committee found that. It's not a mystery.
Thank you.
The Secretary of the Labor Party said that. I notice Mr Wright's not here today. The Labor Party found that. The Joint Standing Committee found that. Relevant experts who were bipartisan figures have found that. And I think, just to finish, Mr Chairman, this enhances the law by empowering voters, and that's a good thing.
Thank you, Mr Nutt. We do have time for one additional question. The calls with Labor. We've got about 2 minutes remaining. Senator Carr.
Mr Nutt, I've heard your explanation of the way in which the preferences arrangements are currently done. The current arrangement that we have before us wouldn't exclude that, would it? And secondly, it's been put to me last night that part of the price for getting the Greens' support for this measure has been discussions between the Liberal Party and the Greens about the Liberal Party preferencing directly to the Greens in inner city seats in Melbourne and Sydney. Can you confirm that?
There's a few comments, Mr Chairman. I'll just take a moment or so to deal with that. It's a federal election year. All parties, including your party, Senator, are actively involved in discussions with other parties, with individuals, with independents, with all sorts of people about public policy issues, about leadership issues, about policy issues, and about who they may or may not support in the House of Representatives or in the Senate. That's all part of the democratic process. And you're a pretty vigorous participant in the democratic process yourself, Senator Carr. Parties have those discussions. Are people all around Australia and parties having discussions? I'm sure they are. But what will be relevant about those discussions, both in the House of Representatives, is their recommendations from parties. We put out a how to vote card and we respectfully ask electors to support Malcolm Turnbull and support this range of people. electors decide. And in the Senate, under these changes, the elector will decide, not the party official, the elector will decide. So they will be, whatever discussions anyone has, they'll be recommendations, the voter will be deciding.
But since most people follow a how-to-vote card, your preferences in Wills and in Batman and Melbourne would be decisive for the Greens if they were able to secure your preferences. And you are now confirming you have had those discussions.
No, I'm not confirming any such thing, Senator. That's just you attempting to get something for the 12 o'clock news. Senator Faulkner used to do that. He just was much better at it. The point is, I've said that people have discussions. That's part of the democratic process. But just to assist you, Senator, I'm the National Campaign Director of the Liberal Party. In the Liberal Party, I won't talk about the Labor Party or other parties, that's for them. There are all sorts of discussions with all sorts of people at state and federal level, including parliamentarians, leadership figures, organisational figures, and at the end of the day, decisions are made of preferencing. I've made no such decision, if that helps you, Senator.
All right, thank you, Senator Carr. Now, Senator Xenophon indicated he was trying to get my attention during the Crossbenchers call, and I apologise that I didn't see him, so I will call on Senator Xenophon.
Just one question. Mr. Nutt, you talk about empowering voters. Surely leaving the below-the-line voting system largely as is completely asymmetrical with the proposed above-the-line changes and inconsistent with the Liberal Party's previous position in respect of this. What problem does the Liberal Party have in having an optional preferential system of either 6 to 12 below the line rather than what's being proposed?
Well, thank you, Senator. We're dealing in this legislation particularly with the above-the-line, which is a remedy which will improve the system and empower voters. Below the line, it's compulsory preferential, but with a good savings provision. There was about a 2% informal factor at the last election. With the changes being proposed, that will reduce it to less than 1%. So that's a good thing, and Mr Gray made that point in his speech in the House of Representatives last week. I think for those people who want to do one of two things, fully order the ticket, allowing for savings provisions, or change the recommendations by parties in the order of senators, for instance. And you all know that individual electors will not necessarily just support people on the ticket as recommended by the party, but will change the numbers because they particularly like Senator Reynolds, for instance. They particularly admire her work in the armed forces or whatever, so they support her as against some other person on the Liberal ticket, so they can do that. Or they can fully order the ticket in the order of their preference, giving them maximum flexibility.
It's very asymmetrical.
But the savings provision, I mean, already what do we know about those electors? There was about, I apologise, Senator, I think it's 481,000 of them, the 2013 election. There were about 8,500 informals, about 2%. The reforms being introduced will make it, if you model on the last election, 1%. Less than the House of Representatives. So I think those electors who want to do that are doing that pretty effectively at present, and they've got a full suite of options before them. I'm not sure why we'd need to move from that, given that full suite of options.
All right, thank you, Mr Nutt. Thank you, Senator Xenophon. That concludes the witness presentation by Mr Nutt. Mr Nutt, we thank you very much for your appearance before the committee today.
Thank you, Chairman, and thank you to the committee.
Yes, so we'll call the next witness, Mr Scott Mitchell of the National Party. Oh, it was me. Okay. All right, well, I welcome our next witness, Mr Scott Mitchell, the Federal Director of the National Party of Australia. Thank you for your submission to this inquiry, which is number 17. Now, for the benefit of Hansard, would you please state your full name and the capacity in which you appear before the committee?
Scott Anthony Mitchell, Federal Director of the National Party of Australia.
Thank you, Mr Mitchell, and I know we've allocated 20 minutes for your presentation today, and I'd now invite you to make a 3-minute opening statement.
Thank you, Mr Chairman. I'll be brief, as I have made a short written statement. I thank the committee for the opportunity to appear before you today, and as always, we welcome the opportunity to contribute to one of your inquiries. As stated in our recent submission, the Nationals welcome and support the Australian Government's proposed legislation to reform the way in which senators are elected. In our 2014 submission to the committee, we encouraged the inquiry to investigate reforms to the current voting arrangements within the electoral system to ensure that voters make more deliberate choices about who they vote for and where their candidate or party's preferences ultimately flow when a vote is made above the line under the current voting system. Additionally, it was our view that deliberate deal-making among the micro-parties, particularly at the September 7 election 2013, resulted in several micro-party candidates being elected with an extremely small share of the primary vote. An example of this is the Australian Motoring Enthusiast Party having their candidate elected in Victoria on 0.51% of the first preference vote, or 0.0354 of a quota. The government's proposed amendments will address these very important issues, and the Nationals commend the proposals to the committee.
Thank you, Mr Mitchell. We'll now move into questions, and again we'll seek to have questions of approximately 5 minutes from each group. Senator Mitchell, could I just ask you to elaborate on your comments regarding the current arrangements into group related to group voting tickets and the allocations of preferences and the transparency or lack thereof of those allocations to the average voter? Is that something that concerns you?
It certainly is something that concerns us, and we've made the point many times before that group voting tickets aren't well understood by voters. They're very complex, having been involved in lodging a couple of them over the years. I think a very small number of people have a thorough understanding of exactly where their preferences are going. I think a very small number of voters are going to go and print out the hundreds of pages that you would need to print out from the AEC website to examine them and to understand where their votes are ultimately going to end up. And I think that, we think that these the proposals to before the committee at the moment will essentially put the power back into voters' hands on where they direct their preferences.
And in saying that, you mean through the allocation of above-the-line preferences by the voter themselves in the Senate, as opposed to the allocation through group voting tickets?
That's correct.
And what do you see as the virtue of that relative to the existing system? Why do you think the new system is better?
Well, I think that voters are going to be able to very clearly make their own decisions about where they're going to direct their preferences, rather than have it done like people like me behind closed doors.
Mm-hmm. Could I ask you also in relation to the issue of the logos on ballot papers? As you'd be aware, it is proposed in the legislation that parties as an option could include a logo on the ballot paper for the purposes of identification. Is that something which you think is a sensible measure, and if so, why?
Look, it is something that we believe is a sensible measure, and as mentioned by Mr Nutt just before, this is an optional provision, and it's something that we will all be able to consider doing, but we believe that it will assist voters in making a decision about who they wish to vote for.
Mm-hmm. And in your experience, Mr Mitchell, the process by which group voting tickets are formulated and so on, I think you alluded to before, having some understanding of this process. Is that something that is fully transparent to voters, do you think?
I think it's completely non-transparent to voters, which is why I think this proposed system will be a huge step forward in letting voters ultimately determine where their own preferences go.
Okay. And in relation to the provision to have optional preferential voting above the line, that is something, again, the provision of asking voters to number the boxes at least 1 to 6 above the line, which is proposed in the legislation. That is something which you think is sensible?
It is. It's something that we strongly support, and it's something that we will be advocating how to vote cards, encouraging people to vote.
And could you just outline why you specifically support that aspect of the legislation?
Like with House of Representatives voting, we think it's important that where there's a provision that voters can preference boxes 1 to 6, we will be providing advice, like I imagine other parties will, to voters to consider following our advice. Ultimately, of course, it's their own decision, and they'll be able to ultimately determine where they put their preferences themselves. But like everyone else, we will be providing some recommendations.
All right. Okay. Well, thank you, Mr. Mitchell. I'll give the call to Senator Conroy. Thank you, Senator Lynham. Senator Rhiannon.
Not here.
All right. We'll go to Senator Lynham, then we'll come back to Senator Rhiannon after the crossbench questions.
Thank you. Well, I think Senator Conroy has given me his time, Chair. So anyway, just I only have 2 or 3 questions for Mr. Mitchell. Mr. Mitchell, do you think these changes will be positive for the National Party or negative, or make no difference?
Fundamentally, I don't think they'll make much difference. I think that voters still have an opportunity to preference above the line. So in states where we run separate tickets to the Liberal Party or others, they'll still have an opportunity for preferences to flow. So I don't think it will ultimately make any difference.
So in the states where you do run separately, a separate ticket, I think that's only with WA now, is that correct?
I think at the last election we may have run a Senate candidate in South Australia as well.
We've heard previously, do you anticipate that would continue, that you'd run a separate ticket in WA?
Well, that's ultimately a matter for the Western Australian Party.
Right. I don't think that's a matter of relevance to this bill.
It is relevant, Chair, because what we've heard from Mr. Green earlier is that entry level, if you like, for a small party to get to win a seat in its own right is 5 or 6%, and the ability to hand out how to votes. Is the National Party in WA capable of reaching that hurdle?
Senator, I think that is a question which is beyond the scope of this inquiry, which is assessing the impact of the proposed legislation.
Mr. Mitchell is advocating. Mr. Mitchell is advocating support for this bill. It's relevant that we're hearing from a political party that may be adversely affected by it. I want to know whether he thinks it is adversely affected.
Mr. Mitchell can answer the question. He can answer the question with respect to the general impact of the legislation, certainly.
Senator, my view is that, and I've consulted all our state branches on the proposed legislation, that this legislation will not in any way be to the detriment of us running separate Senate tickets in Western Australia or South Australia or other places for that matter.
I guess the point is that if at some stage in the future you and the Liberal Party decided to run separate races, do you still think the National Party would be able to reach the first rung on the ladder, given what Mr. Green has previously told us in terms of how high that rung is?
Look, I'm confident that our joint Senate arrangements in New South Wales and Victoria will continue for some time, and I think it's sort of quite hypothetical to sort of talk about what might happen should that not be the case.
All right. Well, let me ask you then, do you think the legislation, the bills as presented, are optimum from the perspective of National Party?
Look, we think that they are, yes. We think that this is a huge step in the right direction, and it's
a huge step in the right direction is not the same as optimum, Mr. Mitchell.
Well, we think it is optimum. We think 1 to 6 above the line is a very good outcome, and we fully support it.
And do you think 1 to 100 below the line is also optimum?
Well, we think that that what this proposed legislation does is it improves above the line voting. There's also some improvements with improved savings provisions for people below the line who wish to exercise their right to number all the boxes. So yes, we think this is quite optimal.
Thank you, Chair.
Thank you, Senator Lyon. We have some time remaining. Senator Day or Senator Muir within that block. Just have about a minute or so.
Yes, Mr. Mitchell, you expressed a similar view to others, and that is the concern at group voting tickets and backroom deals and so on. If that's such a problem, why not just make it easier for people to vote below the line, to give them a simple alternative, and that is 1 to 6 below the line?
Well, thanks for the question, Senator, but we strongly believe that making it easy for people to direct their preferences above the line is a very good thing, and fully support that. And we think that we are making steps to improve below the line voting for people who wish to direct their preferences in detail all the way through the end by improving the savings provisions so that more mistakes can be accepted.
It's pretty clear that most people will continue to vote just 1 above the line. In that case, then, in all probability, most of those votes for your party will exhaust or will die. What's wrong, in your opinion, of your supporters delegating to you the distribution of their preferences?
I think I might not quite understand the question, but my answer to what I think the question was is that I'm quite confident that our supporters, will direct preferences 1 to 6 above the line.
Okay. Thank you, Senator Day. I'll give the call now to Senator Rhiannon.
Thank you, Mr Mitchell. Mr Mitchell, there's been some speculation here today and some commentary that some people might advocate a just vote 1. Could you comment on if you think that that's likely and if measures should be taken to ensure that that doesn't happen?
Well, I'm not really sure that I feel confident to speculate on what people may not do down the tracks, but the current proposal is where the Electoral Commission will advise people to vote 1 to 6 above the line, and I'm quite confident that most people will do that.
So with regard to just voting 1, that's not something that the national parties would entertain in saying to people?
That's not the News Providence answer.
I was just asking the question. So the National Party wouldn't be advocating a just vote 1?
Well, the National Party will be will be advocating for a vote of 1 to 6 above the line, strongly.
And some have argued that the proposed system, the Senate voting reform changes that we're looking at in the bill, would deliver the coalition Senate majorities forever and a day. What's your response to that, please?
I'm never going to underestimate the ability of independent senators or other getting candidates elected around the place. So I'm not really in a position to speculate on how many seats one party or another might not win. At the end of the day, this new system is going to make it imperative for us all to get out and work hard to earn our votes.
So what you're really saying is that the changes pushes it back onto the politicians, the candidates, to get out there, to have real engagement with real people, to win votes. Is that what you're saying?
That's correct, Senator.
Thank you, Chair.
Thank you, Senator Rhiannon. Senator Conroy, I think you don't have any questions. All right. Well, I think we've had 3 allocations and we're just on time. So I think we will thank Mr Mitchell for his testimony. Oh, okay. Did you have any further questions, Crossbench, that you'd like to ask? You're okay? All right. Senator Muir does? Senator Muir, thank you.
So in 32 years the current system's been in place, there seems to be a lot of confusion still amongst the community, within the community, of how the system actually works. How confident are you that in such a short time frame, potentially a few months before the next election, that the party, with no agenda, of course, to get themselves elected or misrepresent people to vote 1 to 6, the message, the education will get across clearly?
Well, I'm very confident that the Electoral Commission will be able to run should this legislation be adopted, that the Electoral Commission will be able to run a very good education campaign to explain to voters how it works. And I think that what the committee has determined and what this proposed legislation proposes is that a 30-year-old system can be improved to essentially give electors the power to direct their own preferences as opposed to party secretaries.
That's exactly what I wanted. So improved to give the voter direction of where their vote goes. So you say this is to allow the voters to make their own decision where their vote goes. So why did the government, the Nationals, the Greens, Senator Xenophon, All ignore the recommendation to have the optional preferential voting below the line.
And later.
Sorry, Senator, I don't...
Well, I think Senator
Why
Mr
was
Mitchell
the
can ask questions
recommendation?
on behalf of the Nationals.
Okay, so on behalf of the National Party, why is a recommendation to have optional preferential below the line being ignored and just changes above the line?
Well, I don't think...
This is about the voter being able to choose where the vote goes. That's where it happens.
So when we made our original submission, it's clear that, you know, we made the strong point that the system needed to change. And there was a lot of ideas being floated at the time, about 2 years ago. And we put forward some thoughts on that, like others, which improved making below-the-line voting less intimidating. We believe that what these current proposals do is essentially deliver that in an easier way for electors to make it more possible for them to, in an unintimidating way, direct their preferences the way they want to direct them in a very simple way above the line, which is what they're accustomed and where the vast majority of people are accustomed to voting.
6 Senate positions, why isn't it minimum of 6 with no saving provisions at all?
Yeah, look,
make it clear. You said the education system's going to work, so why aren't we looking at 6 minimum above the line?
Well, that's, in my understanding, what the recommendation is, that people...
1 to 6 and a savings provision. So people who have been voting above the line for 32 years, which is, according to Anthony Green, going to happen significantly, will benefit you, and to those who are 1 in 4 voters are voting elsewhere, what do you think is going to happen there?
attracts the majority of the vote. Go and do that.
I think, Senator Muir, I think you may not have accurately described what Mr Green said earlier today, but I think I'd ask Mr Mitchell simply to respond generally to your question about the nature of the proposal for above-the-line voting, which, as we know... Excuse me, could I have order, please? Senator Rhiannon. Senator Rhiannon, thank you. Senator Conroy, thank you. The provision, as we know, Senator Muir, is for voters to be instructed to number at least 1 to 6 above the line. And I think you're asking for Mr Mitchell's comment in relation to that proposal generally. So, Mr Mitchell, if you could...
Well, we
respond,
strongly
please.
support the government's proposal to encourage people to vote 1 to 6 above the line with a savings provision. I guess I'm confident, and we're confident that over time that savings provision will be needed less and less as people exercise their right to vote.
Correct me if I'm wrong, but if they vote 1 above the line, like traditionally people have been for 32 years, doesn't that mean that that party receiving enough votes then gets to choose where their preferences go, but nobody else?
Sorry, Senator.
So if people are voting 1 above the line by default, by accident, because they're used to the old system, they're not choosing where their preferences go. They're still up to that party.
Well, I think that's what it's incumbent upon parties and candidates to do, to encourage people who are going to support them with their first preference vote to direct their to encourage them to direct their preferences elsewhere after that.
All right. Okay. Look, thank you, Senator Muir, and thank you very much, Mr Mitchell, for your appearance before the committee today. Thank you. All right. We'll now call the final witness to appear before us today, Mr Glenn Drury. So I thank you, Mr Drury. I do welcome you to our public inquiry today. Now, for the benefit of Hansard, could you please state your full name and the capacity in which you appear before the committee?
Glenn Drury, and I was invited here by the committee.
Thank you, Mr Drury. I understand that you'd like to make an opening statement, please go to that statement.
Okay. I analyse voting systems just like Anthony Green, Malcolm McKerris, George Williams and Tim Bonham, who you heard from earlier. But unlike them, I advise people who start up political parties, small parties with ordinary people. Minor parties are merely dealing with the system that's been handed to them from the major parties. They're small, so they benefit from getting advice from people like me. The current system was introduced in 1984 to deal with Australia's very high informal voting rate, and it largely fixed that. All the major parties have exchanged preferences with each other in a way to improve their chances in the past. These days, They seem to have a problem when small parties do the same thing and actually get elected. I'm not claiming that the system is perfect, which is why I favour the adoption of a system similar to that used in the Victorian Legislative Council. This involves numbering 6 below the line and one above the line with a group voting ticket. The current system has advantages and that we'll see disappear under the proposed changes. We have diversity in our parliament. Changing the rules to exhaust roughly 25% of the vote doesn't address the issue that major parties are less popular today than they have ever been. These changes are being sold to us as reform to improve democracy. But even if they were, there's no getting away from the fact that the legislation is about a tactical shifting of power. It's almost a form of electoral schoolyard bullying, or we don't want people like Ricky Muir playing in our sandpit. In a sense, the Greens and Xenophon got infant industry support in the form of a group voting ticket. Now they want to remove that support for others. In the future, the coalition will be the only party able to hold the Senate in its own right. Labor can't possibly achieve that. These changes may force the Labor Party into a formal coalition with the Greens in response. It also represents a cynical grab for power on the part of Senator Xenophon.
Order, thank you. Yes, Mr Drury.
These proposed changes are designed to exclude ordinary Australians from the political process. It will put us on track for a US and UK-style two-party system, a characteristic of the first-past-the-post electoral regimes. This could cause a Trump-Clinton-style polarisation. People don't like to be ignored in Australia. The Greens have also I believe the Greens have walked into a coalition snare. These changes may benefit them in a half-Senate election, but might not benefit them in a double dissolution election. It would be interesting to be a fly on the wall in the Greens' party room as they rearrange their pre-selection deck chairs. The unions are likely to walk away from the Greens. As part of a double dissolution joint sitting, we'll see the passage of the ABCC and the registered organisations legislation. All I can say is caution. This legislation seems to be rushing through this committee in half a day, so please be careful.
Thank you, Mr Drury, for your opening statement. So we'll now move to questions, and consistent with previous witnesses, we'll rotate the call of approximately 5 minutes, and I believe we've allocated 40 minutes for this witness. Mr Drury, you made the point in your statement that the behaviour of parties in these various complex preferencing deals is clearly lawful under the current system, and that's no doubt the case. The question I think that is important to get your view on is, do you think it's right that that's the way the system works? And do you think it's right that, according to testimony we've heard today, there's very minimal transparency to the average voter in terms of how their preferences are allocated? And do you think that's right?
Well, look, what I think is right is the fact that we have somebody over here in the form of Ricky Muir, who is what I like to term an ordinary person entering this place. Sure, the system's not perfect.
Thank you, Senator.
I'm dealing with the question.
Thank you.
The system isn't perfect, and I think that there is scope for improvement, as I suggested in my opening statement. But I would hate to see the baby thrown out with the bathwater, indeed the entire bathroom thrown out the door, simply to stop what is effectively a system that allows people who are not in the major parties to come into this place.
So just to be clear, so when you say allows that to occur, it's correct, isn't it, that it allows that to occur through a complex system of preference allocation which the average voter doesn't understand at the point at which they place their vote? That's a fair comment, isn't it?
That is a fair comment, but it's a system that wasn't put there by minor parties. It was put there by the major parties and has been tinkered with by the major parties effectively for about 100 years.
So the issue, I think, before the committee is, if we have a system currently where I think that most of the witnesses before the committee today have acknowledged is not overly transparent or well understood by the average voter. The question is, can that be improved? And that's obviously what this legislation seeks to do. Is it your view that it is preferable for these preference deals to ultimately determine the outcome of who's elected to the Senate, relative to a system where the voter themselves chooses to allocate their preferences above the line? You think
Look, I think you can have both. I'm not suggesting the Victorian system is the ideal system, but it's pretty good. It's not difficult for anybody to vote 1 to 6 below the line or 1 to 12 in a double dissolution election, with the option of ticking every box if you wish, and a simple 1 above the line. I think that Senator Day said earlier today, what's wrong with people who trust their parties to vote 1 above the line? Honestly, I think in this case we can have our cake and eat it too. 6 below the line or 1 above the line.
And you also made, in your opening remarks, some comments about the diversity of the parliament, that being a good thing. Isn't it fair to say that the proposal would certainly allow individual voters to preference parties in any order that they determine? So should they determine that a particular party should be allocated their first preference, another one second, another one third, and so on, to their heart's content, really, in terms of the number. That's what this system would provide for, wouldn't it?
Well, in theory, yes, but look at the New South Wales system and what actually happens there. Most people just vote 1. The last election we saw for the first time, or second time actually, where preferences have made a big difference, and the Animal Justice Party were elected on, as I recall, about 1.9% round figures. The reality is, in the majority of elections, that ordinary people will be excluded if you adopt the system that this committee is, I think, going to recommend.
But just to be clear, Mr. Drury, if a voter chooses to preference any party whatsoever, regardless of whether it's a mainstream party, a small party, medium-sized party, any party, they're able to do that under the proposal, of course, and they are able to determine in their own mind what the appropriate allocation of preferences is as and between those different parties. That's right, isn't it?
And what I'm advocating is that they should be able to do that below the line, but we can still vote 1 above the line. We can have our cake and we can eat it too.
And so you don't think it's appropriate that above the line, when choosing between parties, that voters... thank you, Senator Conroy. That you don't think it's appropriate that when choosing between parties above the line, that voters should be able to allocate preferences as they see fit. You don't think that's appropriate?
Look, we can change the laws and make them more draconian if you wish, that it exclude everybody other than those in the coalition, the Labor Party. But I think we must have a system that allows diversity. And if we go down the road of some form of optional preferential above the line, we'll stop that. So what's wrong with optional preferential below the line and simple 1 above the line?
All right, thank you, Mr. Drury. I think my time has elapsed. Senator Conroy? Senator Conroy, so we move to Senator Rhiannon.
Did you want to go?
Unless Senator Brown or something.
Okay. Thank you, Mr. Drury. In the lead up to the 1999 New South Wales state election, how many parties did you help form?
Look, that was a long time ago. I don't recall how many people I advised, but there was a lot.
So there was 81 parties. You helped register many of them. You actually had expected to get elected from comments you made at the time. So could you give more of an indication of...
I don't recall comments. What comments were they?
Well, but to ask the question again, how many parties were you involved in setting up? 20, 30, 40?
Look, I don't recall.
Most of them...
certainly since then, I think I've been involved in helping people form over 40 political parties.
Over 40?
And there's a few at the moment.
So those political parties are parties designed to play a role in the group voting tickets. They're not parties, this is a question, I'm not making assumptions here, I'm just saying, is it a political party that's got real members, that's got a platform, that's out there engaging with the public to win support, or are they parties that have been set up to be part of a group voting ticket to funnel votes?
Look, you'd have to talk to the parties about that.
But you've said you've helped set up 40 parties, so
yes.
You could obviously give an indication about that, Mr. Drury.
Look, I would be betraying private conversations, but I can say that the minor party operatives are a very eclectic bunch, and political parties are established for all sorts of reasons. Some of them think they can win. Some of them want to make statements in the political arena by simply running and getting access to the media. Others want to run in lower house seats and use their preferences to influence their positions. So I can't address your question specifically because I simply don't know the answer.
So can you address specifically, have you been paid to undertake this work? Is it true that you were paid by the shooters and fishers to undertake this work, to assist, to set up parties, to funnel votes, to benefit from group voting tickets?
Senator Rhiannon, I don't think that is relevant to the inquiry.
I think it's highly relevant, Chair, because Mr Drury has been one of the key people involved in using group voting tickets, and at the essence of this legislation, at the centre of the legislation we have before us is the removal of group voting tickets. So how Mr Drury works is obviously very relevant, and if Mr Drury could answer the question, it would be helpful.
Senator Rhiannon, I've obtained advice from the Secretariat on this point, and it is not appropriate to ask Mr Drury in relation to his personal financial matters. You can ask him about people he's represented and so on in the past.
Thank you. It is. I think it should be recorded that Senator Conroy was supporting me on this one, but we will.
You should be able to ask questions.
We will move on. Is it true in your view that the more parties that are registered and part of a grouping of parties exchanging preferences via group voting tickets, the greater the chance that one of them will be elected?
Mathematically, that theory would be correct, yes.
So that's been the basis of how you have worked in terms of running those forums and running the round robins that you have organised to inform people that they have a chance of getting elected. So that's the basis of it?
No, that's not the basis.
So what is the basis, please?
Minor parties should work together, in my opinion, before they deal with the major parties. And my advice to minor parties is to, where they can, exchange preferences amongst themselves. Obviously, there are sometimes philosophical reasons why that can't happen. And some of those parties will preference major parties of varying colours before they go to other minor parties. I think you're referring to the minor party alliance meetings that I've been running or hosting since 1999, is that right?
Yeah, no, that's what if you can provide.
These meetings are predominantly networking opportunities for minor parties.
And do you concede that it is a flawed electoral system if it provides an incentive for a person to register lots of parties because that provides electoral advantage?
As I recall, Senator, it was this so-called flawed electoral system that put you there in the first place, and quite a few, as I recall, political parties were set up by Greens sympathisers leading up to the 1990 election.
Well,
do you remember that, Senator?
No, absolutely not.
Mr.
I mean, you are again being deceptive and not answering the questions.
I'm not being deceptive.
You've got the examples, put them on.
Order.
In 1999,
Senator Rhiannon,
the Wilderness Party, the Animal Liberation Party you created, and you still won't put it on the record.
What about the euthanasia referendum party that Green supporters...
You've talked about ordinary members.
What about the parties that your supporters...
Mr Drury, Senator Rhiannon, Senator Rhiannon, please address your question to Mr Drury. Mr Drury, your role is to answer the questions.
Mr Drury, you have said in your... Mr Drury, you said in some of your opening remarks and to earlier questions your commitment to ordinary Australians being involved in the political process, and you're concerned that the changes will exclude ordinary Australians from the political system.
Most likely, yes.
Don't ordinary Australians have a right to decide their preferences?
Yes, they
rather
do,
than backroom
and that's why
deals?
I advocate 1 to 6 below the line.
Well, above the line, why do you not support a system where preferences will be required to be allocated up
do you
to
mean
6?
The system that actually
I'll just finish
you?
my question,
Is that what
please.
You mean?
I will just finish my question,
last
please.
question, Senator.
The proposal for above the line is to allocate preferences to 1 to 6. Clearly, we all know that that would require people to also be preferencing minor parties. So here we have ordinary people deciding their preferences, and they can be electing minor parties. If we have real parties engaging in a political process on their election platform, engaging with people rather than getting out of the backroom deals. Isn't that the way to have ordinary people voting and determining their preferences and ordinary people being elected?
Thank you,
the reality of the situation is, Senator, you benefited from a form of electoral subsidy when you were elected, and now you are in the room. We'll pull up the drawbridge. It's unlikely that minor parties will make it through the system the way you did, the way that Senator Xenophon did. If you adopt a 1 to 6 above the line or 1 to whatever above the line, it will exclude minor parties.
Right, thank you, Senator Rhiannon. Senator Rhiannon, your time has elapsed. Senator
I don't have a business
Senator
model.
Rhiannon, your time has elapsed.
Minor parties equate to minor money, I can assure you.
Thank you, Senator Rhiannon. Order, thank you. We now move on to the crossbench time allocation. Senator Day.
Thank you. Words like, or phrases like gaming the system and preference harvesting seem to be fine for 30 years whilst those preferences ended up with the majors. Isn't it the case that the minor parties and independents just got a lot better at preference arrangements than the major parties?
I won't single out any of the major parties as to how well they negotiate, but I mean, there's a little bit of talent there, but it could be better. Look, Senator, you're right. The system that we've had in place has been there for a long time to benefit the major parties, and we see that. We see that with until the Democrats came along and then the Greens, which now, by the way, are part of the political corporate mainstream, and they've walked well away from their grassroots.
Order. Senator Rhiannon, Senator Conroy, could we please listen to the witnesses' responses?
Yes, I think it is a case that minor parties have developed an understanding in recent times of how the system works, and we see good people such as yourself and Senator Lanehelm and Muir as a representation of that sitting there now, contributing toward what I believe is a very mature democratic process that does allow ordinary people to enter the political system. Right now in the US, we see a two-party state, and I would ask people like a rhetorical question, Senator Rhiannon, you don't have to answer this. Do we want to go down the route of the US? Do we want a two-party state? I would think that most Australians would say no.
Okay.
Senator Day?
That's it, thank you.
Senator Muir or Lanehelm? Senator Muir.
Yeah, thanks, Chair, and thanks, Mr Drury. Do I have to declare an interest about now, or no? I think I bypassed that bit.
Well, if you paid him money, you could.
In the beginning, the
Paid him money, Ricky.
No.
Thank
you're
you.
quite
Order.
right.
Order. Thank you, Senator Muir. Please, thank you, Senator O'Sullivan. Senator Muir, please address your question to Mr Drury.
In the opening, the Chair asked if the current system can be improved. Is this half-day Senate committee, which had over 100 submissions, which closed last night, sufficient enough to discuss real reform to a 30-year-old process?
The decisions made here, or the recommendations made here, could impact legislation that the Australian community will be dealing with for decades to come. I suggested in my opening statement that this was a tactical move on the part of the coalition. I firmly believe that. I could talk about the polls and how the Prime Minister is going down in the polls, and it would be to his advantage to go to a double dissolution, but I won't talk about that. But others do talk about that, and we are well aware that there are many people within the government that have leaked dates in early July for an election. So I would go so far as to say if the Greens listen to their supporters and back out of this deal that they've been hoodwinked into, that we probably will not go to a double dissolution, and it will be a tactical failure for the coalition.
Senator Muir.
Thank you. Thank you, Chair. What effect will the savings provisions have on voters who put their faith in minor parties to direct their preferences for them?
That's a good question, Ricky. I think little effect.
Yeah. So do you think those minor parties, those who might want to vote for the hemp party or something, would their vote exhaust if somebody goes and accidentally votes one above the line?
We can see from the New South Wales example that there is quite a high exhaustion rate. I believe that if we adopt the system that's being discussed here today or something similar, that we will have a very high exhaustion rate. Something over 3 million voters voted for parties other than the majors at the last election. That could well be closer to 4 million this time if we look at the trends. And quite a large percentage of those people will effectively be voting for nobody.
So just to explain to the public, it's your interpretation of the proposal with the above the line, that if somebody went one above the line to a minor, it would exhaust there and go no further?
Yes, let's just say we voted for the XYZ party and they pulled 0.1 of a quota, if we could just use a number. That 0.1 of a quota is very likely to exclude. And if you multiply that over 20 or 30 parties, then you can see we're getting into quite substantial numbers.
just for the ease of the listener in there who doesn't quite understand the current system in place, do the major parties have to deal with preferences?
Do the major parties deal preferences?
Yes.
You mean under this proposed system?
Under the current system?
Oh, certainly. It's compulsory preferential voting in the current system.
Thank you.
They do, yes.
Yeah.
And might I say, over the years, some of them have used that very well. In my experience, in recent times, the Greens have had some very good operators. And many people argue that it was certain personalities in the Democrats that caused their failure. It may well have been, but certainly the tactical moves on the part of the Greens behind the scenes in backroom deals contributed to that.
All right. Well, thank you, Senator Muir. Thank you. That's our time allocation for the crossbench. All right. So I'll just follow up, if I may, Mr. Drury, with a couple of questions. I just want to come back to this central point. I think one of your arguments is that that minor parties are, potentially disadvantaged by these changes. I think the point I just want to focus on is, if somebody wants to vote for a minor party, and if somebody walks in to a polling place and says, look, I want to vote for X, Y, Z, and I want to allocate 1 to 10 or whatever as they may be, that's what this legislation provides for, isn't it? And to the extent that it disadvantaged a party, that could only really occur if the voter, in fact, chose not to vote for that party, couldn't it?
Yes.
And why is that a bad thing?
I think that anything that takes away diversity in the parliament is a bad thing. And that's why I come back to the, if you like, have your cake and eat it too option, and that is what you're suggesting, below the line. But for those that wish to vote above the line, they can simply vote 1 above the line. Now, with an education process, I think that could work very, very well. You could explain through the AEC and other organisations, if you wish to nominate your own preferences, you do so below the line. Not numbering every box that we have at the moment, that can be tedious, although I do that at every election, but simply 1 to 6 or 1 to 12 in a full Senate election. And if those that wish to vote above the line and trust their parties, then do so. Vote 1 with a GVT.
But why is it a problem for the purposes of voting above the line for the voter to have the opportunity to choose from the full gamut of parties and determine, based on their own views, how those parties should be preferred?
Why is it a problem having choice? And I'm advocating choice.
So yes, but not with respect to the allocation of preferences above the line. You're not advocating choice.
Well, there's a big black line there, and I'm advocating that people have a choice below the line. They can preference whomever they wish, but they can also vote 1 above the line and trust their party to direct their preferences.
All right. Mr. Drew, you made some comments before just around I think in response to one of the questions about the talents or the issues involved in managing these quite complex. Senator Rhiannon, have order, please. In managing these quite complex preference deals. Now, I understand that's something you obviously have some expertise in. Is that a process that is something that you're obviously quite familiar with?
Am I familiar with the preference system? Is that what you're asking me?
No, the process of allocating the preference deals, so to speak.
Oh, I have an understanding of it, yes.
Okay. And to the extent that this legislation proceeds, what would be the role for those complex sort of behind closed doors preference deals? To what extent would that be affected by this legislation?
Well, I mean, let's see the colour of the legislation, as I
Based on the
understand.
draft.
It would remove, if the group voting ticket is removed, then largely many of the negotiations over preference deals would change, certainly, yes.
So,
well, that's a different story.
So
that's a very different story.
So just to be clear, so if the legislation in its current form passed the Parliament, the requirement for those existing complex preference deals and so on would be lesser because the the voter themselves would be allocating the preferences. Is that right?
There would still be preference arrangements in place, and that could look like this. For example, the Greens may do a deal with the Labor Party, perhaps, and that might see voters directed on the how to vote card, vote 1 ALP, 2 Green, 3 whomever. Similarly,
Yes.
the coalition may do a deal with, who would you like to do a deal with? The Christian Democrats? And 1 coalition, 1 Liberal National, 2 coalition, and so on and so forth. So certainly negotiations would not end. There would be a form of negotiations continue, and often these negotiations are clouded with what goes on in the lower house. And I'm very well aware that deals have been in place for many elections between the Greens and the ALP, where Greens demand ALP preferences in the Senate. In response, the Greens will preference the ALP in certain lower house seats. So look, negotiations will not end. They will change, but they will not end.
So I'm just about to pass the call to you, Senator Conroy. Just last question. So just to be clear, whilst it would obviously be possible for parties to allocate particular preference deals in or allocations in their how to vote cards for above the line, as you allude to, the formal allocation of preferences in a somewhat mechanical fashion as exists now when someone votes 1 would not occur anymore, and it would be up to the voter as to whether or not they adopted that preference allocation as recommended by their chosen party. Is that right?
The mechanical positioning would be such that the voter would have to actually mark numbers or ticks or squares or whatever in boxes.
Yes. Thank you. All right, give the call to Senator Conroy.
Mr Green indicated his analysis, and I'll try and use the exact words, of voting under the new system. It would be much more likely that the Liberals would get 38 in the Senate. In your view, would any minor parties, other than Senator Xenophon, who is a South Australian phenomenon, shall we say, any other minor parties survive in this voting system?
It's unlikely, and it's unlikely that any minor parties will be born, if you like. We saw the growth of the Nick Xenophons, the Greens, the Democrats, and as I suggested in my opening speech, with a system that offered some form of protection, if you like, to help small parties become established until they were, well, in the Greens' case, moved away from their grassroots and more part of the mainstream, and now they no longer need that protection. In my view, it is unlikely we will see that develop into the future, and it is very likely that we will ultimately move to a 2.5 party state. Xenophon, I believe, made an unfortunate choice of name when he put his name in it, and when he eventually retires, I think his party will retire with him. Certainly, forever is a long time in politics, but in the foreseeable future, assuming Xenophon stays around, it will be the Greens in some type of coalition with the ALP. They will be forced into that, because the ALP under these changes will very rarely, if ever, have control of the Senate in their own right. The only organisation, the only group that will be able to do that will be the coalition. Will that happen in every election? Unlikely. Every second, third, fourth cycle? Who knows? But it will certainly happen.
But in terms of a blocking majority at 38...
the coalition's the only group that can do that on their own. You may see a situation where there is a balance of power position with the Greens, and so the ALP or Xenophon, coalition, Xenophon, Greens, I mean, these things shift around a lot, as you know.
Okay,
thank you, Senator. Senator Rhiannon, did you want to ask any further questions? Or,
No, I'm right, thank you.
All right, we'll pass on the call to the crossbench. Senator Lundhelm.
Yes, the comparison with New South Wales Legislative Council has been drawn a couple of times today, and in after the 1999 election we saw abolition of group voting tickets in New South Wales. What has been the impact on diversity in the New South Wales Parliament as a consequence of that change, and why, explain why that has occurred?
We do draw comparisons with New South Wales, and this system that's being advocated is somewhat similar to New South Wales. However, there's one big difference, and that is that New South Wales has
the 21 members that are elected there by the quota is 4.5%. We have 6 individuals elected in the Senate, or 12 in the full Senate, but the quota is dramatically higher. So, albeit we have a system that is biased toward the major parties in New South Wales, like this proposed system, it does make it much easier for smaller parties to enter the process in New South Wales because the quota is so much less. So in terms of what does it mean for diversity in New South Wales, well, we have, of course, the coalition represented, the Labor Party, the Greens, the Shooters and Fishers Party, Christian Democrats, and recently the Animal Justice Party. Did I get them all?
And this is my final question. Where do you, in relation to the preference deals that will be discussed in terms of this new proposed, or this new intended legislation, so what will occur on the how to vote cards, who will discuss those preference deals and where will those discussions occur, do you think?
Do you want me to use the term back room?
It could be back room.
Or coffee shop, or
Could be.
over lunch somewhere, because that's how it happens now.
Mm-hmm.
All of the parties have these preference negotiators, and I'll use it again, these backroom deals have been going on forever, and they will continue.
Thank you.
Thank you, Senator Muir. Did you have any further questions? All right, I'll pass the call to Senator Reynolds.
Thank you very much, and thank you very much for your testimony, Mr Drury. I just want to pick up a few points with your discussions with Senator Rhiannon. You said that earlier on that you're paid to advise on the Senate voting systems, and you're paid by political parties.
Oh, I didn't say that. Senator Rhiannon did.
So it would not be fair to say, so you provide this advice for free? You're not actually paid by political parties or individuals?
Much of the advice I provide is for free, yes.
But that's not my question. So my question was, is this
Senator
free
Reynolds,
advice or paid advice?
Senator Reynolds, we have advice from Senator Conroy. Senator Reynolds, order,
Chair, I'll rephrase
Senator
it.
Rhiannon.
So you have clients? So, Mr Drury, you have clients?
No, Senator O'Sullivan has a point of order, yes.
Just point of order on your ruling. I think this very question is a significant question and goes to the heart of how much weight someone like me on this committee can give to the evidence of this witness. He's either a paid player or he's not. Well, the others haven't hidden behind it. We know that they're paid to provide their advice to their political parties. So
yeah, Senator O'Sullivan, thank you. Senator Carr, thank you. I have obtained...
He hasn't said that.
Order. Yes, Senator O'Sullivan, thank you. I have obtained advice from the Secretariat on this specific issue, and the Secretariat advises that those questions are not in order. You can, of course, ask Mr Drury about his professional expertise in this area.
Well, I didn't actually write down the words, but you said that you provided advice to over 40 political parties. Is that correct?
Oh, it'd be many more than that.
Okay, how many political parties have you advised on Senate voting practices?
I'd have to refer to notes, but since 1999, I don't know, over 100.
Okay, so somewhere over 100. How many of those parties? So you talked about having some of these parties, nurture them till they can survive and thrive on their own. So how many of those 100 parties would still be in existence now?
I looked at some numbers about a year or so ago, and they of course have changed. So this is just an in principle answer that I give you. As I recall, from 1999, over 250 minor political parties have been registered at state and federal level. Of that, within 2 to 3 electoral cycles, the overwhelming majority of them...
Sorry, Mr Drury, you misunderstood my question. In terms of the 100 or plus that you have personally advised, how many of those, not the all 250, of the hundreds that you've been involved in?
I'm sorry, can you repeat that?
I'm not asking about an analysis of all political parties, just the 100 or so that you have advised.
Look, it's probably well over 100. When I say advised, I've been running meetings for minor parties that the press referred to as the Minor Party Alliance since 1999. At the very first Minor Party Alliance meeting, there was 50 groups. At the last meeting, what was it, 3-4 months ago, there was probably 45 groups. So certainly the figure of 100 is an underestimation. It could be
I honestly don't recall.
The answer is you're not quite sure how, you can't give me the precise number of how many of them.
Well, you ask about advice. Advice is me standing up in front of a room with perhaps 100 individuals representing 30 or 40 political parties, and I talk about how the system works. That's advice.
Okay. Now, at what point, we've had some testimony here that suggests that in terms of the preference distribution, that you have parties who have a particular name, like, you know, Forest Conservation or the Sex Party or whatever, and people actually look at that name and think that there must be some philosophical underpinning that reflects their name. So when you've been advising these 100-odd parties, Senator Carr, you were heard in silence.
Order. Senator Reynolds has the call.
At what point, when you provided...
Order. Senator Carr, Senator Conroy.
At what...
Senator Reynolds has the call and she will ask her question. Senator Reynolds has the call and she will ask her question without interruption.
Mr. Drury, thank you, Chair. At what point, Mr. Drury, in these discussions, do you, when you're providing advice to these parties, consider the linkage between the party name and actually the party philosophy that underpins that political party, so that when voters are making a choice, if they're voting for the party, how do they know that party stands?
This is really a question for any given individual or group that comes to me. It's not a question for me. I will make suggestions on names, of course, but if somebody comes to me that represents, say, a Christian group.
Okay, so in your advice, in your advice, it's about how to manipulate the system. It's not about how to link or how to develop a philosophy. It's not about how to manipulate the system at all.
Or a name. It's about how to work within the system that people like you have put there.
When does the voter's intent, so when you're advising on how to do group voting tickets and do the preference deals...
Sorry, can you repeat the last one?
At what point do voters, like the people up in the gallery now, at what point does their will come into it?
Well, when they walk into to vote, their will comes into it. They can choose where they vote.
The time has elapsed. Senator Reynolds. Senator Reynolds. The time has elapsed, and in keeping with the resolution, we will conclude your questions at that time. The time for this witness has also elapsed, and Mr. Drury, we do thank you very much for your testimony before the committee today.
Thank you for inviting me down.
That concludes today's public hearing. I thank all witnesses for providing evidence to the committee today, and I thank Hansard and Broadcasting. A proof transcript of today's proceedings will be posted on the committee's website. The committee is required to table its report in the Parliament tomorrow morning. This hearing is adjourned.